But here, what I've indicated the corrections. Only the date of the master summons would be correct.
My lord, may I be permitted to mention, my lord? This is execution matter, my lord, chamber matter. May it appear in the list, my
lord? May I have your lordship's kind leave? This is not a chamber matter, my lord. This is a matter which is fixed by your lordship today at 3 o'clock. It's item 44 in the list. My lord, may my learned junior, because I'll be praying for a adjournment in the matter, my lord, because I'll not be available in the second half. My learned junior, it is fixed at 3 p.m., my lord. 3 p.m. We'll give notice to the other side in the meantime, my lord. I'm very deeply obliged, my lord.
My lord, I appear on behalf of the plaintiff, my lord.
It's my application. I'm the defendant, my lord. It's my application. It's a chamber matter, my lord.
My lord, it has come on assignment, my lord. It has been assigned to your lordship.
My lord, it may appear, my lord, any day, my lord, any chamber day, my lord. I am for the defendant.
I am for the plaintiff.
The application is mine, my lord.
Yes. Sure.
We have to go vacation or after vacation?
Before vacation is the application for extension of time. It will not take much time.
Next Thursday, my lord, so one promise, my lord.
15.
Lordship.
15/5.
15.
Temper application. Lordship.
All the new chamber application at number 4. Number 3.
Lord, I appear for the applicant in this matter.
Yes.
Yes, ma'am.
Then they had come last.
Lord, they had come, they had filed their affidavit in opposition.
File their affidavit.
Yes, my lord.
Learned advocate for the plaintiff is present.
My lord,
My-
my lord, on the last day, Mr. Abhijit Mitra was making submissions. My lord, the decree was for we filed this petition seeking an amount of rupees 10.53 crores. My lord, in the affidavit in opposition, my lord, the respondents have admitted a sum of rupees 4.37 crores.
Actually, the executive court cannot go beyond the degree. Whatever they may admit something, they may admit nothing.
Yes.
The executing court has to confine itself within the degree.
So, my lord,
Anyway, you file your reply.
No.
my lord, we don't
Not
want.
necessary.
No, my lord, reply is not necessary. My lord, we are only seeking.
Advocate for the plaintiff is present, as affidavit in opposition is already filed to the execution case 16 of 2024. Let the same matter appear.
My lord, on the last day, your lordship had heard Mr. Abhijit Mitra, my lord, and my lord, this was kept fixed for orders only for this prayer.
Let this matter.
My lord, will it be your lordship's pleasure to? My lord, Mr. Mitra is here, my lord. I'm being led by Mr. Mitra.
Again, they are not
On
here.
the last occasion you submitted with regard to the matter, and affidavit in opposition is already filed. Your learned junior is telling that affidavit and reply did not be filed.
No.
Okay.
Has been filed.
Affidavit in reply has been
Reply.
filed.
Reply
Not necessary.
not necessary at all.
Okay.
I am what I was asking, what I was humbly praying for that day was, lordship can wait. How many times are in a court will wait for them? Be that as it may.
Okay, I'm making it.
No, well, all I am saying is that in the
4.37 crores.
affidavit in opposition, they have said 4 crores is payable.
See, the executing court cannot go beyond the degree. They may say 4 crores, they may say 1 crore, they may say nothing.
Exactly. So what
The executing court has to confine itself within the degree. It has reached its finality.
According to the decree, as per the calculation which we have given, it is 10 crores something, from which there is no appeal has been preferred, dismissed. So what I am saying is 10 crores is lying in the fixed deposit. What I am humbly submitting is this, that at least give me what they are saying in their warped calculation, which is wrong palpably. I am not going into the correctness of the calculation. We shall wait for them another 2, 3, 4 times, I don't know how many times, because there are several orders giving them the last chance. But at least give me that much, what
Anyway,
they are themselves saying.
however, as the affidavit in opposition is already filed, learned, Mr. Mitro, learned advocate for the decree holder petitioner is present. Affidavit in opposition to the application is already filed. It is submitted that affidavit in reply need not be filed as the judgment debtor has admitted part of the decretal amount. However, let this matter appear for orders on 13/5/2025
In the same position, madam.
and in the same position. Yes, orders will be passed on that day.
But you kindly once again.
You are appearing in this matter?
Yes,
You have filed your affidavit in opposition.
Yes, my lord.
I'll record your presence. So let me pass necessary orders on the next day. Anything to submit?
Yes, my lord.
Yes. Take record to them. Your affidavit in opposition.
Give me the people. People. Lordship, may I move the application, my lord?
Move করো।
So you have
আপনার
submitted.
জন্য তো wait করা হচ্ছে। Lordship kindly comes to the decree, which page? Give me the page number, let's please. Kindly come to the decree of the learned single judge. That's the drawn up copy. Lordship, the decree is at page, my lord. Let's take.
It's my next meeting.
That's it, page number 99. 99.
Page 99 is the decree passed by my lord's court. Kindly come to page 99. Kindly come to page, at operative part is page 106. The second paragraph of page 106. So far as CS 72 is concerned, tenancy is a part of second floor premise number so is in question. So Deepak, they calculated mean profit rate of 800 per square feet per month from the month of February 2006 till December 2010. In my considered opinion, reasonable rate of mean profit should be 85 per month per square feet carpet area, along with interest at 18% per annum, with 15% increase of the mean profit after 3 years from the month of February 2006 till December 2013. This should be corrected to, till December 2010. But this was corrected to 30th September 2013. Lordship kindly comes to page 122. Lordship, page 120 first. We came to correct the order, page 120.
Yes.
While correcting it, there's another mistake cropped up. At page 8 of the judgment order, 30th September 23, instead of 2013, shall be substituted. It shall substitute the word December 2010.
It's September at page 8. Yes, page 8.
Page 8, second paragraph, last line of the second paragraph.
30th September 2013.
It should be 13. So it is not December 2010. It was corrected to 23 by mistake. Typographical mistake. So we mentioned once again. And Lordship, thereafter at page 122, the correction was made.
Ultimate correction was made in
On 15th of December 2023.
page 122.
So this is the period. Now, page 123 is the calculation.
Yes.
Here's the full breakup calculation given. 85, then after 3 years it becomes 97.75, and thereafter 112.41. Initial
10 crore 52 lakhs.
Yes. Now an appeal was preferred from this.
This degree of mean profits.
This was, of course, not moved by them. This was moved by them only after we put the decree into execution. And the order was passed in execution at page. Lord, you kindly come. That's in my lord's files. Order was passed for attachment. That is 26th of June 2024. An order was made. Lordship kindly comes to the 26th June 2024 order.
26 June 2024.
There is an earlier order. There is an earlier order which I am giving before 26th of June, Lordship.
It's a May order.
15th April.
Yes.
There's an April order, first 15th April, directing this money to be kept apart.
So where is the order of the appeal court?
The appeal court's order. I'm handing up a certified copy. They are just simplicity, heard at length and then dismissed.
Anyway, the appeal fails.
So, Mother, this money is due and payable to me. Now, Lordship, may I come to the affidavit?
Yes.
Kindly comes to page 4 of that.
4 of?
The affidavit in opposition, what is there, please? Page, paragraph 8. Without prejudice,
Have a Xerox copy. Supply a Xerox copy of
We'll give
this.
the
appeal. Yes, page 4.
paragraph 8. Without prejudice and subject to result or other any order that may be passed in the appeal preferred by the judgment, the total service 4 crore 37 lakhs is payable to the decree. Subject to adjustment 67 lakhs, with the accrued interest thereon covered under fixed deposit receipt as mentioned here under. Full particulars given in photo. Because Lordship, they are saying 67 lakhs is what was deposited when their by court order while the suit was pending. Now, Lordship kindly comes to annexure. Lordship kindly comes to annexure A, page 8.
Yes. Yes.
This Lordship will kindly note the most important fact is kindly compare the two charts, mine at page 123 and this chart prepared by them. It is, so far the rate of mean profit is concerned, our calculation is correct.
You're at page 108.
Page 123. 123. The first rate is correct. Thereafter begins the drama.
That is from 2006 to 2009.
6 to 9, Lordship will find it is the same at 85 rupees. And A and B are both correct. Now, Lordship kindly sees the calculation in their chart. What is the rate they have taken? The rate they have taken for A, as you can see, calculation for A, total square feet 4745, period 3 years,
Yes.
85 rupees per square feet. That is also my rate, which is in my chart. Kindly come to calculation B. It is 15% every 3 years. 4745, 15% increment, 97 rupees. Same as mine, 97 rupees. Kindly come to third one, C.
Yes.
Rate after 15% increment. How can it be same? After 3 years increment, 997, after 3 years is increases by 15%.
So it is 47. So 1 year, 8 months. So rate after this
No,
is
no.
15%.
Rate after what is the rate? I am on the rate.
Yes.
Rate is after 15% increment on 97 rupees.
Yes.
Cannot be 97 itself. Because first it was 85. After 3 years, 15% increase becomes 97. After 3 years, again 15% increase on that. So it becomes 112.41.
After 15% interest, it cannot remain the same.
Same.
That is 97.75.
The period is correct. 1 year, 8 months is 1 year, 8 months, 20 days is correct. 1 year, 8 months.
So,
So the
15
period first, that's where it cannot be 50% increase every 3 years. The first 3 years they've given the increase, second 3 years they've kept it the same. Next, my lord, kindly comes to the interest. The interest.
So did you give me a breakup in this?
Yes, we have.
The Lordship kindly sees
That is
page 123.
123.
Rate first is period, second is rate per square feet per month. 85 rupees we start with.
Yes.
15% increase, 97. That also there. I mean, this is calculated. This can't go wrong.
Yes.
And another 15% increase thereafter, after the 3 more years, it is 112. Now you can ask any my officers to cross check. It became 112. And anyway, it is impossible. 97 increased by 15% does not remain 97. 85 increased by 15% becomes 97. 97 increased by 15% has to be more. So
Calculation for C is disputed.
yes, C is not this. I mean, there's no question of dispute now after
It is-
the
it is
decree.
finality.
Yes, after the decree, there is no dispute. It is, or she will ask any Mala's officers to just take a calculator and calculate it. Then Lordship takes the interest part. Interest also, Lordship, kindly comes. Interest is continued. In fact, now the nut will go up even more because this was up to sometime in. This calculation is up to
6th October.
when we file the application.
So this,
Filed in
So this is-
2015.
December 23.
This calculation is up to December 23. Our calculation. So the interest we have calculated, Lordship, take the now let's come to the interest part. Lordship, let's look at their calculation A.
Yes.
A. Total square feet 4745, period 3 years or 36 months, A rate 85. Mean profit 4745 into 85 into 36 is 1 crore 45 lakhs. That is same as our column 3. Our third column 1 crore 45 lakhs. Now interest per annum. interest per year,
That is
that is
12.
on, that is on rent of rupees 85, it's 8%. So the interest they have calculated per year is 4745 into 85 into 12. It should be per month. Because interest becomes payable rent becomes payable every month. Now she kindly comes to rent becomes so should be calculated from that date. It is calculated 8% per annum. But from the date the rent 85 rupees for the month of say it starts from 1st February 2006. What falls due in the month of February 2006? Interest is calculated from 1st of March 2006. You don't wait for the end for the year to end and then calculate interest.
Interest for the with regard to February rent will not be the same with regard to the November rent. So that is the principle.
Exactly. And also they have stopped after 3 years. Why after 3 years? Interest is not, the money hasn't come to me. It has to be calculated. Here it is till December 23, but now we are in.
Is the thing you see, as because it has reached its finality, the court's jurisdiction is only with regard to
Only,
section
but
152. If
Absolutely.
there is any arithmetical
That has been done also. Lordship.
only 152.
Only
150.
152. Only 152. That has been done, the correction. So the interest calculation is all haywire. They firstly also why interest for 3 years? Interest will be calculated on that amount. See what February 2006 what fell due. Interest is from 1st of March. You start calculating interest 1st of March 2006 until it's paid. After 3 years, interest will not stop running.
That is what you see, that interest for the month of February,
2006
yes, will not be the same as
for
that of
March
May
or
that of
April.
June or it will
And
be
also the
vary.
yes, and also the interest will be calculated till it is paid.
And
So
it is reflected. So far, your calculation is concerned.
it is up to
process.
date. It it is calculated up to December 23. In fact, there will be 4 more months interest that have fallen due. January, February, March, April of 25.
That is from the decree, date of the decree till realization.
Whatever decree says will be payable 8% from the date when the decree says from the date when the money becomes payable. It was calculated from February 2006. So the interest they have gone, it's much less. So if only the first year 85 rupees is correct here, the
Principles is concerned, principle of calculation and arriving at the figure is concerned, it has reached its finality.
Lordship,
Only this
only the matter of calculation.
only with regard to the calculation, and if it is there, then 152 at best.
But there's no correction in decree anymore required, my lord. So, my lord,
Computation of
computation is not 152. Computation is as per decree, my lord. Whatever lordship can
this, if
ask,
there is any mistake,
whatever will lordship, as you started by correcting me by saying that I can't direct 4 crores. I have to direct payment of what is payable under the decree.
suppose they instead of 4 crores, they say only 1 crore is due and payable.
I
Or if
bow
nothing
down
is
to.
due and payable.
Yes, well, so I correct myself with what lordship said. I was wrong in saying go by admission. Admission is irrelevant post decree because post at the execution stage is what is payable under the decree, irrespective of what one
If you are
says.
challenging this computation, it's better you file your affidavit.
Well,
in
here my calculation is given here. No, my calculation is
Good
given
calculation is given. You are now disputing this.
here. Lordship,
The very basis, okay. I think for abundant precaution, you analyze and you give your calculation, file your affidavit in reply. Let it be on the record.
I was humbly submitting, my lord.
Yes.
What they are saying, it is their lesser calculation. As per lesser calculation, theirs comes to 4 crores something. So let me take for the time being 4 crores of rupees.
Yes. How did they dispute this figure?
No, they are not disputing the figure at all.
So in affidavit?
Now she kindly comes to their affidavit, page 4. Paragraph 8, without prejudice.
Yes.
They are saying 4 crores 37 lakhs is payable. has given an extra day. They have simplicity done their calculation, apparently erroneous calculation, and saying, according to me,
That's why it's better, instead of making submission, you better dispute this paragraph in paragraph 8 in your reply. You justify, then it would be, I think it would be clarified the position.
all Lordship what I was humbly submitting, my lord. Lordship, what I calculate, what he calculates is immaterial. Lordship kindly ask one of my lord's officers to just calculate what is payable. Because this is a matter of taking a calculator and putting in the figures and multiplying. Because I will show this by my original calculation is right. They will again deny it. So this calculation denial, then we have to bring a calculator and start calculating in front of my lord. That's not the way to one can do it. So Lordship,
This is how they have denied us.
So, Lordship, what I was humbly submitting is, as your Lordship, whatever Lordship says, we will do that. But after all, we can't be just calculating in front of you and then showing it. If you can ask any my lord's officers to just calculate the figure.
Dispute this paragraph 8. That is the only thing.
But
Paragraph
well,
8.
I
Nothing
have
else.
given my figure at whether I dispute or not, as your Lordship corrected me at the beginning.
Yeah,
What I admit, what I dispute is immaterial. Lordship has the decree now. Parties, what they say is immaterial. So whatever is that the decree, Lordship has hands are, with all the respect I can command, hands are tied in the executing court. So whether I dispute or I admit is immaterial. Lordship kindly ask any of my lord's officers or anyone to calculate and give the figure to my lord, whatever is payable in terms of the decree. And then we both
The appeal court has accepted the principles of arriving at the
mint of
figure.
it.
So the
And
principle,
the
so
interest
the
rate,
principle is concerned.
principal 85, 15% increase every 3 years, interest 8% per annum. Those have all been accepted. Now, the appeal court has left it for the calculation because it depends calculation, it changes every day. If they had paid that very first day, it would have been one figure. If they say now if the execution goes on for several months, it has to be calculated till the date. It is finally I get my last paisa. So that way I can calculate and bring it. My calculation will be the same as what was there.
Your written notes of arguments. Calculation in your written notes of arguments.
Written notes of argument. But whatever is there, I will just give the breakup.
Just
Just the
list
breakup.
of the notes and that calculation.
And whether I say 10 crores and they say 4 crores, Lordship, really our submissions are material. Lordship is here is the decree, page 106,
Yes.
and it's a matter of calculator and putting in the figures.
52 lakhs 65,304.
Yes.
This is the
Maybe that's the wrong calculation. Maybe that's the right calculation. But the Lordship ultimately, Lordship is not bound by either what I state or what they
that
state.
they have not disputed. In
They have not
this-
disputed
in
this.
affidavit.
No. They have not disputed. They have not disputed. They have simply given their own figure.
Paragraph 7.
Is anything else to add?
No, well, that is really all.
Yes.
My lord, the executing court will not go beyond the scope of the decree. That is the principle. It is known to everybody.
Okay, may I have my kind leave, man.
So, my lord, decree has to be accepted as it is. There cannot be any, I cannot raise any dispute as far as the decree is concerned. And that more so because the appeal court has also not interfered with the decree. So, my lord, I have to start my submission from the decree itself.
Yes.
And it has to be shown to your lordship that as to whether the execution application which has been filed calculating certain amount of money is payable, whether that has been done in accordance with the decree or not. That is the only scope of this execution application.
Yes.
Now, my lord, kindly come to the decree. Page 99, it starts from page 99. My lord, I tell you, lordship, what happened in this matter. In fact, this page 99 deals with two suits. We are concerned with CS 72 of 2006.
Yes.
My lord, kindly come to page 106. We are concerned with this CS 72 and let us see what the decree has said. Now, may I place this? So far as CS 72 of 2006 is concerned, tenancy in respect of the part of the second floor of the premises Park Street is in question. Mr. Deepak Dev calculated main profit at the rate of rupees 100 per square feet per month from the month of February 2006 till December 2010. In my considered opinion, reasonable, well, this is the decree. In my considered opinion, reasonable rate of main profit should be rupees 85. So therefore, my lord, the main profit is fixed at rupees 85
Yes.
per month per square feet carpet area, along with interest 8% per annum. This is also fixed, my lord, 8% interest. Now, with 15% increase of the main profit after 3 years. My lord, kindly mark these words after 3 years. It is not after each 3 years. It is after 3 years, it is a flat increase of 15% interest instead of 8% per annum. Here, my lord, the problem lies. The calculation which has been made by the decree holder, that they have shown the increase of 15% every 3 years. That is not the decree. So therefore, I started my submission by saying that the executing court will not go beyond the decree, my lord, the principle. So this is the decree. Now kindly comes to their calculation. At page 123. My lord, square feet is not in dispute, rate is not in dispute, principal amount is not in dispute. So, my lord, question of section 152 does not come at all. I am not challenging anything of that. My lord, kindly.
So you are interpreting the decree.
Yes, it is not a question of interpretation either, my lord. The decree itself is very clear. Had it been the intention of the court that there would be increase in every 3 years, then the word would have been like that. It is only 15% after 3 years. Now, my lord, kindly come to page 123. So they were proceeding on that wrong notion, and my lord, giving the effect of the decree of every 3 years. On that basis, the calculation has been made at page 123. My lord, kindly see. First is 1st February 2006 to January 2009, 85 is the rate, no problem, no dispute. Then 1st February 2009 to 31st January 2012, 15% increase, 97, no dispute. All of a sudden, from the next year, 1st February 2012 to September, it became 112.41. How it has come? It would be that the same rate of 15% interest of this only few days, February 2012 to September 2013.
That is about one and a half.
Well, what about the date? So it, according to my calculation, it comes to 97.75 paisa. Now, my lord, kindly see, in addition to that, did the court says in the decree to pay this GST, CST, all these things? Is it the scope of the decree? He has come before the executive court to execute the decree. So executing court will only look at the decree and nothing else. Court did not say that you have to go on paying in addition to that all other taxes and other things. Now kindly take my affidavit in opposition. And there is no dispute with regard to that. Kindly take my affidavit in opposition. Kindly come to paragraph 7.
Yes.
With reference to paragraph 17 of the affidavit, I dispute that the decree holder is entitled to sum of rupees 10 crore 52 lakhs account as per particulars given in annexure M, that is 123, to the said affidavit. I deny and dispute the correctness of the said calculation as given in annexure M to the said affidavit. I say that according to the calculation of the receivable amount as made in annexure M is erroneous, inasmuch as the same has not been calculated strictly in accordance with the terms of the said decree dated 6th October 2023, as corrected thereafter, inasmuch as the decree holder has wrongly calculated the mean profit and enhanced the rate for the period 1st February to September 13. So that is the last period. The decree holder has wrongfully calculated at rupees 112.41 for the said period instead of 97.75 as ordered by the Honorable Court. Similarly, the service tax interest amount as calculated on the said amount, which will be further reduced. Next matter, paragraph 8. Without prejudice and subject to the result of any order that may be passed in the appeal preferred with the judgment data, a total sum of rupees 4 crore 37 lakhs is payable to the decree holder, subject to adjustment of rupees 67.99 lakhs with the accrued interest deposited in. What happened when this decree was it was before the appeal court put me on terms that you deposit such an amount of money.
That is how much you deposited?
67,099.03. Now it has accrued interest, my lord, as on date. As mentioned, full particulars of rupees so and so whereof are given in annexure. Now, my lord, take my annexure. My lord, may I request your lordship to come to page 5 once of my affidavit. I say that the judgment debtor had, in fact, in terms of the earlier orders of this appellate court, had kept a sum of rupees 67.99 by way of fixed deposit in the credit of CS 72 of 2006, not in dispute, 2006, and the said fixed deposit together with the accrued interest are lying with Mr. Sanjeev Kumar Trivedi, their own advocate. Of the
Paragraph 12, we are reading.
Well, paragraph on the top of paragraph 12.
Yes.
At page 5. May I read it again, my lord, for your lord? I said it. I am coming from I said. I say that the judgment debtor had, in fact, in terms of the earlier orders of this appellate court, had kept a sum of rupees so and so by way of fixed deposit in the credit of CS 72 of 2006, and the said fixed deposit together with accrued interest are lying with Mr. Sanjeev Kumar Trivedi, advocate on record of the plaintiff decree holder, who is holding the same as receiver thereof, appointed by the order dated 30th June so and so. I have annexed that order. So therefore, I am entitled to get credit of that money together with accrued interest thereof. Now, my lord, kindly see paragraph 12. The particulars of the said fixed deposits were furnished to Mr. Fox and Mondal solicitor, because previously Fox and Mondal was an advocate, by a letter of judgment debtor's advocate dated so and so. The plaintiff decree holder, in spite of knowledge of the said fact, has suppressed the same from this honorable court. I say that after adjustment of the same of rupees so and so, judgment debtor is liable to pay so and so as per calculation sheet annexure A hereof. Now, my lord,
After adjustment of 67 lakh.
the principal amount.
No,
The principal.
yes, it comes to
4 crores so and so. Well, it will be further reduced if I take calculation of the accrued interest of that money.
so according to you,
4
437 lakh is due and payable.
Due and payable. And how it has due and payable? Now, my lord, kindly take my calculation. Page
8.
page 8. Yes, well, I'm sorry. Now, my lord, kindly say top of that. Serial number ABC. My lord, periods are not in dispute. First two columns relating to the periods not in dispute. The third one, 1st February to so and so, principal amount of mean profit 92 lakhs, simple interest 7.42. And my lord, I have now kindly see calculation A, I have given the breakup towards the bottom of that. Total square feet 4745, my lord has seen. No dispute about that square feet. Period 3 years, 36 months. That is 1st February 2006 to 31st January 2003 years, 36 months. Rate is confirmed 85 per square feet. So mean profit 4745 is the total square feet, into 85 is the rate, into 36 is the period. It comes to 1,45,000 square feet. My lord has seen. Interest on that amount, my lord, it comes to 3,87,192. Interest for 3 years, so 3,87,000 equal into 3 years, it comes to 11,67,000. Similarly, calculation B is same, my lord, same rate, same calculation I have given. 15% interest was increased there. I have given that. Now, may I read it? Total square feet 4745. Period 3 years, 36 months. Rate after 15% increment. I have given the calculation of that. It comes to my lord, so and so per square feet. Mean profit 1,66,000. Interest per year so and so. It total comes to 13,58,000. Then calculation C. It has to be given on the same. Only it is period is 1 year 8 months. And the same calculation I had given as per the decree. How they had come into the finding before your lordship, my lord, that it has gone to that height. And there is no, and my lord, also, my lord, kindly consider, in the execution application, there is no whisper about the money they are holding. And where from this GS
Money is deposited.
with them? It is, but what happened during that continuation, it was a chapter 13 application and all these things. So I was put on terms that you deposit such and such amount of money. Initially, Fox and Mondal was
Trial.
during the trial period, during the stage. But I have given the order. At page 9, my lord, kindly see.
Yes.
That is the order. This is an application on behalf of the petitioner who has filed a suit against the defendant for a decree for peaceful vacant possession of the tenanted portion of the premises so and so. Landed counsel appearing for the petitioner places order dated so and so passed by a division bench in appeal filed by the respondent defendant hearing, by which Mr. Partho Basu, my lord, my advocate on record, then, being the advocate on record of the defendant, was appointed as the receiver without any remuneration for keeping a sum of rupees 1 lakh as occupational charges deposited by the defendant, invested in a short-term fixed deposit in a nationalized bank until further orders. Counsel submits that since Mr. Partho was died on such and such day, some other person may be appointed as the receiver in place of the said Mr. Basu. The defendant is represented. Upon hearing the learned counsel, this court deems it fit to appoint Mr. Sanjeev Kumar Trivedi, the advocate of the receiver, without any remuneration, to carry out the directions as given by the appeal court, the order dated so and so until further order passed by the suit. Now, my lord, turn the page. Now, this letter was written by Partho Basu, addressing to Sanjeev Kumar Trivedi, who was appointed as the receiver. This is reference to your letter date, and have noticed. Due to inadvertence, the statements was forwarded to Mr. Fox and Mondal. Well, what happened? They wanted to have the statement that to show that how much money is deposited and where it has been deposited. The statement was inadvertently sent to Fox and Mondal because they were the initial advocate on record. That is why this letter was being written. Due to inadvertence, the statements was forwarded to Mr. Fox and Mondal, who duly received the same. However, the statement of the fixed deposit deposited pursuant to the order passed by the court on so and so is enclosed. Now, my lord, kindly see, this is the statement. This is the statement. Now, kindly come to page 13. The sum total comes to 67,99,030.
So this was on account of payment of occupation.
Occupation charges. So this money has to be given credit to. So therefore, my lord, this four crores which I have admitted, yes, it is payable because I cannot avoid my liability under the decree. So therefore, this money I am ready to pay, but they have calculated in such a big amount.
4 crores. 4 crores means total due and payable.
Total due,
including the occupation
including occupation charges, including the occupation charges. So how they have calculated this, my lord?
So 4 crores, there is now, so at this stage, there is no question of adjustment of the occupational charge.
For this 4 crores after adjustment.
No, after adjustment, it comes to 4
4
crores.
crores.
Yes.
4 crores.
This occupational charge is not reflected in the execution case.
No, it is not. It's which one of that? Each কত? 8. এটা তো শুধুমাত্র তোমার মেইন প্রফিট। ইন্টারেস্ট এত তো এত minus 32 lakhs. 39. My lord, your lordship's query, my lord, will get it. Page 8, my lord, kindly come once. I have been as fair as possible to the court, my lord.
Yes.
Page 8, my lord, kindly says, towards the bottom of that. This is the total calculation. Now, total amount payable excluding GST, total mean profit 4 lakh 4. Interest from 2nd February 2006 to 13, 32 lakh 39,507. Total minus this 4 crore 37 lakhs. It comes to 437 lakhs. I have said so. So, but the two things, my lord, taken in
Regarding GST, it is not applicable in case of execution.
in the execution. Yes, that is not the court's direction. And interest. Court did not say that interest has to be increased in every 3 years.
And tax is not to be borne by the judgment debtor.
Yes. That is the only scope, my lord, of this execution application. I started by saying that I cannot go beyond the decree. Court is not also not going to beyond the scope of the decree. This is the decree, it is bound by me, I have to pay this.
Regarding the 3 years and regarding the
GST.
that is your submission.
That is my submission.
And so, as per your calculation, it is 4 crore, that is 37 lakh.
That is, and that is not in dispute, my lord, also. That is my, that's all.
You want to reply?
May I come back with my affidavit and reply?
No, not now, not at this stage, my lord. My lord had given them opportunity, no. I am strictly
You have to reply to the what.
My lord, there are 2-3 issues which have been raised by my lord.
First of all, my lord, record my strong objection of any prayer for any reply at this stage.
Okay. Learned advocate, Mr. Learned advocate for the petitioner,
Hold on.
decree holder, and learned advocate for the opposite party judgment debtor are present. Petition made on behalf of the petitioner, decree holder, and opposite party judgment debtors. However, as the submission in reply is to be given
Mr. Mittu has specifically refused to file any reply, my lord.
submission with regard to submission
My lord, because there was no opposition at that time.
made by submission in reply is required to be made by learned counsel for the petitioner decree holder. Liberty is granted to make such submission on, I'm keeping it on Thursday,
No, this Thursday.
coming Thursday,
Lord, next, will it be your lordship's pleasure to keep it next week or not? Next Tuesday?
13/5/2025. Although learned counsel for the opposite party decree holder strongly objects the grant of liberty to file affidavit in reply
After conclusion of the hearing.
after submission. However, in the facts and circumstances of the case, an opportunity is granted in the interest of justice. Let affidavit in reply be filed and copy be served by 8. Because matter thereafter holidays, the
Yes,
matter
my
will appear. 8/5/2025.
8 June,
8 May.
No, 8th of this month.
8th of this month.
Yes, yes. Reply to be served upon you.
Today, aaj ko tarikh?
6th.
6th. But day after tomorrow.
No, affidavit in reply to be served by
Say, served
8.
8th. Oh, yes, yes, yes.
And this matter to appear on 13/5/2025 under the same heading
Agreed.
and same position.
Grateful, my lord.
না, এই এখনই যে Yes.
Item number 4,
Lord, this is my application. I am appearing for the defendant number 1. Lord, I had filed a written statement in the suit.
Yes.
Lord, I am seeking amendment of that to incorporate certain facts which, Lord, had happened
Or for the plaintiff opposite party.
The plaintiff opposite party, but a document which he seeks to introduce is of
All the plaintiffs.
yes, my lord, all the plaintiffs, all the plaintiffs. But,
For defendant number
1.
but I'll be seeking, praying for time to file an affidavit to this 1998 document he seeks to introduce now.
He did not pursue his suit
learned
at all.
advocate for the petitioner defendant number 1 and learned advocate for the opposite parties plaintiff. Opposite parties plaintiffs are present. And application being GA7 of 2025 is filed by the defendant number 1 for amendment of the written statement. Learned advocate for the plaintiff prays for liberty to file affidavit in opposition. Such prayer is allowed. Let affidavit in opposition be filed. How long will you take?
3 weeks for an old suit. The old suit will take some time.
3 weeks means that is it will go after vacation.
There are
Okay, let affidavit in opposition be filed on the reopening date of the
Fine,
vacation.
fine.
Let reply be filed by 13/6.
1 more week, Lord. It takes 3 weeks, Lord.
He has all the documents.
Anyway, reply by 16/6/2025. Let this matter appear on 17/6/2025.
Grateful, grateful.
Much obliged.
Item number 5, Substitution,
Your Lordship, I appear on behalf of the plaintiff. This is my application for substitution of plaintiff number 3.
Yes.
The plaintiff number 3 died on 4th November 2024. Thereafter, pursuant to an
So this is application for substitution.
of plaintiff number 3.
When did the plaintiff number 3 die?
4th November 2024.
4th.
November 2024.
Copy is served.
Yes, Your Lordship. Affidavit service has been filed, Your Lordship.
Affidavit of service. Okay, let it be passed over in the first call. If
Your
none
Lordship,
appears, I shall take it up on the next day.
Your Lordship, the defendants have all along not been appearing. In the last amendment application, substitution application also, they have not appeared, and they have been served as well.
So I'm just passing it over in the first call, or I can do one thing.
Yes.
You serve a notice. If they don't appear on Thursday, I shall take it up. Oh, they have nobody entered appearance on behalf of the defendant. They are represented by lawyer.
Yes, but the erstwhile advocate had refused to accept since claiming that he has returned the brief. Mr. Goswami used to appear on behalf of
You serve directly upon the defendant.
yes, directly upon the defendants. Because he refused, he has returned the brief. So in that situation, we had served
We
directly
are
upon
just recording what a learned advocate for the plaintiff is present. None appears for the defendants in spite of service. However, in the interest of justice, the matter stands adjourned till
my time.
15th. I'm keeping it on 8th. Just on
The
Thursday.
formal application made the Lordship may grant.
Anyway, if none appear on 8th in the same position, it is hereby made clear that if none appears on the next day fix, the matter will be taken up in his
On
absence.
8th.
Day after tomorrow.
Your Lordship, the only more difficulty is that we have to again give them a notice to speed course.
That is not, you can solve it. And another thing is this, it is filed within the period of limitation.
Your Lordship, this application has been filed pursuant to a leave granted by the erstwhile bench, wherein we have withdrawn the earlier application due to some defects and filed afresh on the self-same call offense. So
Anyway,
it's within the
on
limitation because
or else if you want, I can keep it on 13th also next Tuesday. ওটাকে 8 জায়গায় 13 করে দিন in the same position.
Item number 6, Mr. Agro Industries Public.
But I'm for the judgment debtor. I'm a very interesting case here. I'm for the judgment debtor.
Your petition.
My petition. Now,
Yes.
what has happened, my lord? There is an attempt to execute a decree, which has been transferred from.
Who is for the decree holder?
My lord, the decree holder we have served. We have told them yesterday. Today they are not taking the call. My lord, there is a reason behind that. My lord, the reason is if your lordship kindly takes the second volume, my lord, I'll just show one document. With history. On a 207, the last page, my lord. Second volume petition.
Yes.
Record was put up today. Different number of filed is Pyrevi. Today also no attendance has been filed on behalf of the plaintiff from peripheral of the record. Replace the plaintiff has left Pyrevi in this case in 18th of February 2013. The record has been seen by the learned lawyer of the plaintiff for doing necessary in the suit, but the learned counsel for the plaintiff, after seeing the record, put his endorsement. The plaintiff has not met with him since long. This case is the year of 1996, and no proper Pyrevi has been done on behalf of the plaintiff, despite several opportunities given to him by the court. Hence, in the interest of justice, this suit is dismissed for default. So, the execution is attempted of a decree of 2007, but the suit stands dismissed in 2013. Now, what has happened in this matter, after the decree, an order line rule 13 was filed. There was a recalling. And after that, the suit was again put up in trial and was dismissed. Now, what is very interesting, no documents are being found even in this court. The original documents are not there. Now there is a reconstruction where we are not getting anything, not even the decree or anything of that sort. We pointed out to the other side. Now, why I am trying to move your lordship, there is an order of your lordship's court directing me to file an affidavit of assent. Now, on the basis of this document, there is no decree as on date. And they are intentionally, I called them up, I've given them a summons. They are not appearing.
I am giving them one more opportunity.
Kindly gives them opportunity, but for these 2 days, kindly stays any further filing of affidavit of assets. It's here before your lordship, I understand.
Mr. Wright, learned counsel for the judgment debtor, petitioner is present. None appears for the decree holder opposite parties. In spite of service, However, in the interest of justice, the matter stands adjourned till 13/5/2025. Advocate for the judgment debtor is requested to serve one more notice upon learned advocate for the decree order. So 13th.
Well, may I just humbly request him, your lordship is not mindful to grant the stay. But kindly please on Thursday, my lord, I'll inform them by
30, Thursday means day after tomorrow.
and they from here, my lord, when they move the court, my lord, they are very quick. But when I am going to move, my lord, they are.
No. Will it be possible?
Yes, yes.
আচ্ছা 13 জায়গা ওটাকে 8 করে দিন।
I'm very grateful, my lord.
Item number 7, more Rajudri and affidavit.
Yes.
My lord, this is my, I am putting my lord for direction for filing my affidavit against the application. Your lordship directed on last occasion. Application for substitution.
Application for substitution.
Substitution and my lord is sitting as at the abatement. I am for the defendant number 1 and 2.
I will have is your application. It will be heard.
Direction.
You are appearing for
Defendant number 1 and 2.
My lord, this is a substitution.
On last occasion, your lordship directed him to serve a copy regarding this application to us. My lord, yes, my lord, I have, my lord. First, he has no locus to affirm this application. First, I will disclose this why in my affidavit. Otherwise, he will try to make it correct. Second point is, my lord, there is a no amendment of section 5. Suit is already abated.
Question is, you are appearing for defendant number 1 and
2. My lord,
you are holding power for defendant number 1.
Yes, I have filed the wakalatnama, my lord. My lord,
This
the
is for
substantial
defendant number
3 and 7.
3 and 7.
How can 1 and 2
my lord,
object
when right has already been accrued, my lord, I have a right.
in favor of whom? In
My
the
lord,
layers of
I have
3
a-
and
I
7,
have- my
not
lord,
1 and 2.
Is abated, it will be abated with regard to
My
3
lord,
and
my
7.
lord, this is a peculiar facts of the case, my lord. The property which is there.
My lord, they has not appeared. I am entitled.
What I am appeared. I am appearing. Your lordship directed me to.
Allow me to complete. You have your seat. Please have your seat. Let me complete.
Don't push me.
My lord,
Your table is there.
very well. My lord,
My lord, he is personally appearing.
entitled to exemption under Order 22, Rule 44. That if concerned defendants who have expired, they have neither entered appearance nor filed their written statement since
My lord, there is
2010.
one extraordinary suit in which I have filed the written
That is a
statement
different suit.
for self-same cause
It's
of
a
action.
different suit.
For
If we
self-same
are
cause
in
of
this
action.
suit, the lordship would take up my application.
My lord, kindly allow me. I have a right, my lord, to file evidence.
My lord, on the
Let us
last
see
day
what
has
is the
submitted
facts
a
of the
judgment.
case.
The lordship would take up.
He is not allowing me to say that. What
Yes,
is the
you-
fact of the case?
Yes, yes, you please, you will have just your lungs after I complete. Why are you jumping your guns?
So you have prayed for exemption to substitute this.
My lord, instead of praying for exemption, I have asked, I am fair enough to give the heir a chance to file the written statement so that they are active. Now 3 and 7, those heirs have not come forward. They have not entered appearance as since 2010, my lord. Your lordship would appreciate where is the
When
balance
did
of my
when
power?
did this defendant die? 3 and
In
7.
2021
Oh,
2021.
I
Okay.
would think. Let's
and another in 2024.
Yes, your lordship would take up the
Lord-
page 12. Your lordship, page 10, my lord.
Yes.
But this is a letter to the municipality.
Yes. What was the earlier day? On the last day, what was the?
Your lordship
Yes,
directed him. Your lordship directed him to serve a copy this application to us because he was initially
On the
not
last
served.
day too, your lordship
24th
observed that 1 and 2 can't object for substitution
Lord,
of
I
3
can.
and 7. How can 1 and 2 object for 3
Well,
and
I
7?
can because due to the peculiar fact and circumstances of the case, I can, my lord.
1 and 2.
My right also flowed from the my lord, the deceased defendants.
Yes. There is a direction to cause service. Yes.
Yes.
Please record an order. Learned advocate for the petitioner plaintiff and learned advocate for defendant number 1 and 2 are present as service is not caused upon the.
My lord, they have appeared.
On 1 and 2 service has been affected.
After going through the application, we are
Anyway,
making substitution.
As service upon defendant number 1 and 2 is already affected and the learned advocate prays for time to file affidavit in opposition. Let affidavit in opposition be filed by 13/5/2000.
Not for 1 and 2 both. He's
Yes,
like
1 and 2 by 13/5/2025. Reply, if any, by 14,
1 week.
1 week. Okay,
Yes, my.
by 16.
Any day, the minute of
Any day.
not required.
Okay.
In law, it is not required. I have furnished the
Okay.
Supreme
Let-
Court
let
judgment
the-
that
let
is a
this-
binding precedent, my lord.
Let this matter appear on 20th of May 2025 in the same position.
20th of May 2020.
My lord, how can co-defendant appear and object to the substitution?
Let them justify, let them file affidavit. If they can't justify, it will be discarded.
Check just here.
I am afraid I have the DVD with that. This is not available.
Item 8?
Item 8, G number 2918,
Yes.
is not available in my paper. Then look at your file this.
So I'm making it not this week. Come ready on the next week.
But
No, look it. Look after the court hours. Okay. Verify the records. I'm making it not this week.
Until the night, one graduate.
But I appear for the plaintiff. I am opposing this application. Item 9 and 10.
written statement. J13 से शुरू करो ना.
The Lordship will kindly take J number 13 first.
That's item 10.
Item 10 first. That connect same two applications in the same suit.
Page 19, 25th.
A13 is your application.
Yes, both 9 and 13 are my applications. I'll first note it's a suit note for recovery of primarily for recovery of money on account of a particular film was released. The money that came from the film, the plaintiffs claim money on that. That's the in summary, that's the money claim in the suit. So that what happened in the suit, we in the interlocutory court that we contested the matter, but then Millard, the written statement we could not file in time. And that when after the interlocutory matter kept appearing in the suit court, that we did not appear, and also that we did not enter appearance in the formal appearance in the suit. So the day when the order dated 25th January 2024 was passed.
So this application you are praying for recalling of the order, directing the suit as an undefended.
Yes.
Defendant number
Yes.
2 and 3.
Yes, I am one. I'm for those three defendants.
So 3 defendants says you are objecting this. So
He is
you file
objecting.
your opposition.
Filed. All that those are
Already filed, yes.
Those are
No, my lord.
He
has no.
oh
No.
opposition then.
Neither of these applications are oppositions. There is no
What?
direction. My
But
lord,
the matter was
my learned
this-
friend is little confused because time and again, my lord, applications of similar nature have been filed, my lord. Lord, this is, I believe, the 5th application of similar nature. If I am not wrong.
fifth.
You file your
Both-
opposition.
I need to file.
The facts
The
of
only
my
thing
lord.
is that when Miller, he's correct. I filed applications of similar nature, and court kept on giving me leave to file proper application. And now Miller, on those stages, my learned friend's contention was that he did not want to file an affidavit. Those are recorded. He did not want to file an affidavit. Now Miller, after when I filed this application, this is composite. Now
Let us see,
problem.
let him go
I have
through
to-
this.
He did not. He wished to file we wish not to file an affidavit.
Okay.
Because, my lord,
And
now I am
advocate
forced
for
to file
the
an affidavit in order to.
defendant number 1, 2, and 3, and learned advocate for the plaintiff
My lord, for the
are
plaintiff.
present. GA number 13 of 2025 is taken up for consideration.
Both Lordship
My
passed
lordship
same order
is
in both
similar.
both.
13
11
of
and
2025 and
G11 of 2024.
11 of 2024 are taken up for considerations. As learned advocate for the plaintiff intends to file affidavit in opposition, the prayer is allowed. Let affidavit in opposition be filed by
My lord, currently
15/5.
my lord, I need because the week following that, my lord, I have some medical emergency. My
Okay,
lord,
20
may I get it 1 week after vacation, subject to my lord.
Let affidavit in opposition be filed by 12/6/2025.
My lord, we are reopening on
9th.
We are reopening on 9th, my lord. May I get 16th till 16th, my lord?
Okay, by 16/6/2025.
1 month.
Reply, if any, by 23/6.
I'll take 1 week.
2025. let this matter appear on 24/6/2025.
Only one thing, Millard, since Millard is such a long time is taken, Millard, let him not also proceed with this suit in the meantime because it's undefended as on this date. So if he proceeds, I'll suffer.
Lordship can, my lord, take it, my lord, I will not. I will not.
I kindly record his undertaking, not I
My
want.
lord, no undertaking is
It is
required.
appearing. It is
If
appearing before this court.
it may appear. Yes,
Lordship will
Lordship
only,
has this
lordship will only hear it.
Just
Lordship
remind
will only.
very, very,
Application is
very-
there, my lord. No undertaking is
very,
required, my
very-
lord. I am
No, Lordship is the.
making
If
submission.
Lordship has determination, I have no problem because Lordship is the also
Yes,
It's before your
If
lordship.
it appears, should appears, you remind me.
definitely grateful. Millard.
Item number 11, more Rajudri and
Well, this is a substitution application for setting aside the judgment of defendant number 3 and 7. Well, it is a connected suit so far as the earlier suit was
Number
concerned.
3,
Same matter, my lord.
same matter, same suit.
And between the same parties, Millard.
Yes.
So this is in US, my lord. This is a transfer suit.
So yeah, you
Same, my lord.
have you filed your Vokalatnama
My
for
lord,
3 years?
I'm Mr. Sengupta's junior, my lord.
No, you are praying
I am
for
for the plaintiff. I am asking for substitution of the heirs of defendant number 3 and 7.
You are representing
Along
which
with
defendant?
setting aside.
1 and 2, my lord, it's the same as the previous matter, my lord. Item number 7.
Item number 7. So item number
Well, this here the facts are different, Millard.
anyway, item number 7 এ যা অর্ডারটা হয়েছে সেম অর্ডার করে দেবেন।
Well, it could be returnable one.
Item 7 এ কবে করেছি? 20th of this month.
Well, I did to just multiply and thereafter it is wastage of time with all due respect.
Anyway, let opportunities be granted thereafter they will not, so that they don't have any grievance.
I don't.
Item number 12, the goods of Sri Vidas Post.
Yes. Pass it over.
Kundalia Vinta Private
Yes, pass it over.
40, Mrs. Nucleus Publishing House Limited. 50, Kishore Kumar Agarwal.
May please, Your Lordship. Well, this is my execution application. Well, the execution application in respect of a decree, well, I'll just briefly about the history. There was an agreement for sale entered into between the plaintiff and the defendant in 1979. Concerning two properties.
Was the decree passed?
The decree was passed on 11th February 2016.
It's a 2 years old decree.
So, but my execution application was filed in 2023. Thereafter, I've served. There have been orders already passed in the execution application.
Yes.
It's not the first time which is coming up for adoption.
Yes.
And so the suit, was essentially for specific performance and an agreement for sale in respect of two properties on Connect Street. In that suit, its property agreement for sale was entered into in 1979, 12th February 1979. Money paid by me, to the seller.
Yes.
Possession was also given to me. The only thing which was left or was not done was registration.
Execution of the deed.
The conveyance deed. That's right. That's it. I mean, that thing wasn't done. I was in possession, so every once in a while I used to ask the conveyor to come and convey it, register it, etc. He always used to say, yes, I will do it, yes, I will do it, yes. Finally, sometime around 2006, he clearly told me that no, I will not do it. That is the point of time when I was constrained to file a suit for specific performance. No claim for possession was required because I was enjoying possession. In this suit I filed an application for judgment on admission to expedite it rather than going through a full trial. In the judgment on admission, my application was allowed and a decree for specific performance was given in my favor.
12th October 2023.
12th October.
No, execution.
First is when a decree was of 11th February 2016.
11th February 2016.
11th February 2016. Page double page?
Yes, page 18. Page 18.
No,
sorry.
11th February.
Of the decree. Decree starts at page. Decree 54 onward.
The page 54 onward is the decree. Perhaps that may not be very relevant right now, my lord, because I can tell my lord before your lordship takes the decree. After this decree was passed, my lord, I was constrained to file this execution application. In this application, my lord, several orders have been. Kindly take, my lord, one of the orders which was passed on 12th October 2023, which is at page 18. So short order, my lord. It sums up my case.
Yes, 12th October
2023. The decree holder seeks execution of a decree dated 11th February 2016. Decree was passed in a suit for specific performance instituted by the decree holder. The operative part of the decree is set out in the affidavit in support of the tabular statement. First and foremost, it should be recorded that the decree holder has made 3 attempts to serve the judgment debtor, 2 of which were by way of postal service and third by way of a paper publication. The judgment debtor has remained unrepresented till date. Service was attempted in August 2023 and in October 2023. The dispute brought to the notice of the court, pursuant to which the decree was passed, arose out of an agreement executed between the parties on 12th February 1979, under which the judgment debtor was to execute deeds of conveyance of 2 properties in favor of the decree holder. Decree holder paid an amount of 1.5 lakh in 1979 for registration and are executing the deeds of conveyance. Turning over the page, madam. The judgment debtor failed to execute the deeds of conveyance and the decree holder finally obtained the decree on 11th February 2016. Learned counsel appearing for the decree holder now prays for an order in terms of prayer A for the tabular statement, which is for a direction on the registrar original side of this court to register the 2 deeds of conveyance in favor of the decree holder in terms of the decree dated 11th February 2016. The decree holder has amended the prayer to an extent by including the prayer for execution in the affidavit in support of the tabular statement. Counsel has taken the court to the operative part of the decree, which also contains a default clause to the effect that in the event the judgment debtor fails to execute the deeds of conveyance, the registrar of the original side of this court shall execute such deeds of conveyance in favor of the plaintiff and or his nominees in respect of the suit property in terms of the said draft deeds of conveyance, and the same shall duly be registered with the Registrar of Assurance, Calcutta. Apart from the decree providing for execution by the registrar original side of this court, Order 23, Rule 32, Sub-Rule 5 of the Code of Civil Procedure also puts a statutory seal on such right of the decree holder. Considering the fact that the decree holder has been made to wait from 1979 and thereafter from February 2016 onwards, that is the date of decree, EC 332 of 2023 is allowed and disposed of by direction on the registrar original side of this court to execute and register the deeds of conveyance, particulars of which would appear from Schedule B to the decree, which can be found at page 36 of the affidavit in support of the tabular statement. The execution shall be in terms of page 74, which is the last page of the schedule to the decree. And thereafter, my lord, we have gone before the registrar. We have gone before the registrar also, my lord. There have been certain corrections, etc., which have been made in this draft deed of conveyance. Kindly, my lord, take one more document, my lord. Which is, my lord, at page 107, one of the minutes, which was held before, my lord, the learned registrar. I'm just going in sequence, my lord, chronologically. So, my lord, this is dated December 5th, 2023. That is after the order of 12th October, which I've just shown your lordship.
Yes.
Learned advocate for the plaintiff decree holder is present, none present for the judgment debtor. Learned advocate files 2 draft deeds with necessary changes at such and such pages. Learned advocate submits that further additions are required to be made in both the draft deeds, like PAN number, etc., etc. The additions as prayed for in both the schedules are as follows, when the 6 things are set out. The above additions in both the schedules as prayed for will give a changed description to the scheduled properties. In my humble opinion, the additions as prayed for should be made with the approval of the Honorable Court. Shri Siddharth Shroff, learned advocate, is required to move before the Honorable Court for obtaining necessary directions. Learned advocate to file the draft deeds with necessary and approved additions along with the sketch plans on the next date. Instant reference be again fixed for hearing as and when informed by the learned advocate. So, my lord, this registrar, my lord, told us to go before the court once again, which we did, my lord. And that order, your lordship will find at page 142. My lord, an order of 30th April 2024.
Yes.
Affidavit of service filed in court today is taken on record. The report of the learned registrar, original site, High Court, Calcutta, dated 25th April 2024 is taken on record. After going through the materials on record as well as the order dated 12th October 2023, I find that the direction as contained in the order dated 12th October 2023 should be carried out. Accordingly, the learned registrar, original site, High Court, Calcutta, to execute and register the deeds of conveyance, 2 draft deeds at pages such and such, incorporating the necessary amendment as indicated in the application being GA number 1 of 2024, after complying with all the legal formalities. The Xerox copies of the draft deeds we also sent to the concerned Registrar of Assurance, Kolkata, for taking appropriate action. List this matter on 11th June 2024 for report from the learned registrar, original site, High Court, Calcutta. So, Malad, we did this as well.
Annexure D.
Malad, that is Malad, the draft deed of conveyance. Draft deed of conveyance. Now, Malad, we have gone.
June was fixed for report.
Yes. Now, my lord, we went back to the registrar, and after going back to the registrar, my lord, the only difficulty which we are today facing, my lord, is that the learned registrar is saying that the execution of this deed of conveyance will take place, my lord, only if I pay stamp duty on this conveyance deed to be assessed on the present date.
And also certain corrections to the contract.
And also certain corrections.
The police station has changed.
Police station, etc. Those are, my lord, formalities which can be complied with, my lord. My humble submission prayer before your lordship today is, my lord, since, my lord, the matter relates to a subject of agreement of 1979, the stamp duty which has to be assessed, my lord, should be assessed on the basis of the market value of the property as it stood in 1979. Because that is the point of time, my lord, when I paid the entire consideration. All the entire sale value was paid by me at that point of time. Today, my lord, naturally what has happened, my lord, is the market value of the property has gone up.
Hence, consideration was paid when?
Then everything was paid then in 1979. Possession was also given to me. And all this is recorded in the decree as well. So today the only difficulty, my lord, it's a practical difficulty. Market value of the property has gone up.
Now, what would have happened? Suppose the judgment debtor is to execute the decree. What would happen? What would have been the stamp duty payable?
He should have executed that time in 1979
very
itself.
well. Suppose after the decree.
Yes.
After the decree, the judgment debtor comes and executes the same.
That is right.
So what would be the stamp duty payable?
That also my humble submission would be, my lord, it should be calculated as on date, my lord, as on the value of the market property in 1979.
Because my agreement for sale was also registered as on that date.
My agreement for sale was also registered document. Stamp duty to the
Without that, it won't have been. It is 176. It's all stamped and properly stamped.
Stamp duty was paid at that point of time on the agreement for sale.
Stamp duty has to be assessed by the collector.
That's
fine. After the it is assessed by the collector. If you are aggrieved by that, you have to come with necessary application.
So that is why I filed this application, my lord.
Was stamp duty assessed by the collector?
Assess
because execution of it, how will they assess?
Oh,
No,
yes,
query
it has to be assessed, and thereafter you have to take these clarifications.
Query to Can you give me one more, my lord?
Execution is amendment.
But when the register goes to execute a query,
we can take out the query if
my lord, we have been informed, my lord, by the learned registrar, my lord, that the market value will be taken as today's value and the stamp.
But it is, let it be on the record.
Very well. Then, my lord, I'll have to get a query raised. The procedure which has to be followed is the query will have to be raised.
Let the formalities be done. Let the matter be sent to the collector.
Very well.
And let a report be obtained. Thereafter, if you are aggrieved, come with an application.
I can come in this application itself.
Application, or you can file a fresh application.
I can bring in an
affidavit. Points of law.
I can bring in a supplementary affidavit on record or something like that. I can do that.
Yes, record and order. Learned advocate for the petitioner decree holder is present. In terms of order dated 30th April 2024, the registrar, original site, High Court, Calcutta, was required to submit a report. As the report is not yet submitted, and the matter is yet to be sent to the collector for necessary assessment of the stamp duty, let the needful be done. Let the copy of the deed be sent to the collector for assessment of the stamp duty, and upon submission, of the report by the collector, let this matter be put up. Learned registrar is requested to take necessary steps for sending the matter to the collector for assessment of stamp duty on or before 19/5/2025. Let the report of the collector be submitted by 16/6/2025. On obtaining the report of the collector, learned registrar is to submit a report before this court. Liberty to mention.
Most affidavit of service. Well, may I keep my affidavit of service on record, my lord, so far as his execution?
Yes.
The affidavit of service.
So let affidavit of service be filed, be kept with the record.
Great.
This service upon
the judgment debtor.
Let affidavit of service filed, be kept with the record.
Grateful, my lord.
My lord's pleasure to take up item number 14, the passed over matter, my lord.
Passed over matter, both sides are present.
My lord, there is no respondent who is appearing. This is a execution proceedings. My lord, may I indicate, I was the tenant in respect of the particular property. My lord, in the with regard to the landlords, the landlord had taken advance
Let
rent.
the list be called out. Thereafter.
Item number 16. Solar Marketing Private Limited.
It's my execution application for the decree holder. Here, my lord, in the month of January, lordships have asked. In the month of January, February, my lord, directions are for file affidavit of asset. Not filed. Lordship has also given time on 17th of April. That's no, my lord, absolutely not. Absolute, it's a false statement.
Between the parties, my lord.
Absolutely not.
You see, you can settle the matter, but how soon can you file your affidavit of asset? Because it is
Lord, 4 months have elapsed. 5 months have elapsed. Kindly do not give any time. Lord, kindly will directs their directors to be present in court. Lord. I have that's my prayer in the kindly see my prayers, Lord.
Petitioner decree holder is present. It is submitted by the learned advocate for the decree holder that in spite of granting several opportunities to the judgment debtor, no affidavit.
Peremptory opportunities,
no affidavit of assets is filed. And today also a prayer is made on behalf of the judgment debtor to grant an opportunity to file affidavit of assets. However, in the interest of justice, a peremptory direction is issued to file the affidavit of assets by 13/5/2025. It is hereby made clear that no further time will be extended.
But I'll only take. No, absolutely not. No, I'm not. I'm denying. There is no settlement talks.
13/5.
Only one prayer I'll make because 2019 decree, we are in 2025. But now, for 5 months, they have not filed any affidavit of asset. I do not know what assets they have. I do not know whether they are disposing of those assets. I have a prayer, let them not dispose of these assets. Prayer B, I have space. I also, there are consequential prayers. Kindly record it.
An undertaking is made on behalf of the judgment debtor that the
assets, they will not dispose of these.
Assets, as mentioned in the schedule of the tabular statement, will not be disposed of.
Prayer B, my lord.
Prayer B. Yes, what is the which assets that is?
But prayer, I have said, Lord, whatever, no.
Immovable properties.
Immovable properties that they have. Movable and both, I have asked for both, my lord.
An undertaking is made on behalf of the judgment debtor that both immovable property and movable property will not be disposed of in the meantime. Yes, come on, 13th.
No, no. Grateful, my lord. Movable will cover bank account, no? Grateful.
Which author and others?
17, my lord, I am for the judgment debtor.
17,
17.
Right.
For the decree. Symbolic position has been taken by the receiver.
And I am applying for the receiver, man.
Today was fixed for submitting of report, and there was also a direction as to when we will be able to deliver the vacant. The only problem is
April 17, there is an order.
Yes, my lord.
Yes.
Yes, my lord. If your lordship comes to paragraph 2, upon hearing the letter of the prayer stands allowed, my lord, we were directed to submit a report.
Receiver was required to submit it.
Receiver was submitted.
Upon inquiring you.
Yes, my lord. Now the only problem is, my lord, that it is a diagnostic center. It was now, my lord, there are technical instruments there. They require at the time of installation also, permission is required from the health department, and also at the time of dismantling, permission is required. Technicians are required to dismantle those instruments. My lord. There are so many instruments in the diagnostic center. So my lord, we require 2 months time to appoint the technicians and get it dismantled and
But this executive code cannot go beyond the decree, so
That's
it has
right.
to be complied.
But it will be complied, but we require some time, my lord, because otherwise the instruments will be get damaged.
Kindly visualize, my lord.
Report of the receiver, let me see.
My lord, last occasion I have submitted a report, my lord.
আরেকটা রিপোর্ট করেছো ভ্যাকেটিং এর?
না, ওরা তো আমাকে কিছু জানায়নি সেই কারণে। ওরা আমাকে কিছু জানায়নি, একটা যাওয়া হয়।
The instruments all shall suffer damages. We will do that.
My lord, I appear for the decree holder. My lord, this can't be, my lord, a defense in an execution proceeding at all. My lord, the decree was passed on, my lord, 5th of March 2024. Today we are after 1 year, 2 months. My lord, if they had to, my lord, challenge it, my lord, they had to do it, my lord, within the, my lord, period. They did not. They have accepted the decree. Now, my lord, it's only a question of handing over possession. They cannot, my lord, hold on to the property by citing all these, my lord.
Cannot be thrown away just like that, my lord. It is not.
It is not, my lord. The decree holders, look out, my lord. The decree holder has a decree of this honorable court. I need possession of the property, my lord, and I am entitled to it, my lord.
Will be delivered, my lord.
Let them, my lord, pay occupation charges then, my lord, for these 2 months, my lord, which they are, my lord, holding. My lord, I cannot suffer, my lord, on both counts.
Pay the occupational charges. It will pay the occupational. But my lord, the instruments are very costly, my lord. Goes to crores. So it creates a lot of problem, my lord. Lot of technicians are involved, my lord. Within 2 months, we'll get it done.
My lord, before the special referee who was appointed pursuant to the decree, the, my lord, entire exercise of, my lord, adjudication is also over. There also, my lord, there was no participation from, my lord, this judgment debtor. 2 lakhs per month is what we have claimed there. My lord, the report is awaited. My lord, let them, my lord, put in that money, my lord, secure me to that extent, my lord, if they want to hold on to the property for another 2 months. And let them, my lord, also give an undertaking, my lord, in the form of affidavit that by this date we are going to vacate after removal of the, my lord, machineries. My lord, the decree, my lord, executing court is only required to, my lord, execute the decree. The decree says, my lord, handing of possession.
How many rooms are there total?
8 rooms are
Eight
there.
rooms.
Yes, my lord.
Very many
And one room
Doctor chambers in how many?
2 doctor chambers, my lord. 2 doctor chambers, 1 X-ray room, 1 blood collection room, and my lord, 1 room with USG machines. And nothing.
Well, there will be
1 X-ray.
One floor, in how many floors?
2 floors, my lord. These are all on ground floors, my lord.
And in the
And first floor, all are empty, my lord.
first floor is empty.
Full empty, my lord. And broken chairs, tables are there, my lord. Nothing else, my lord.
No, first floor is empty after the decree. After the decree, they have vacated first floor or?
No, my lord. Nothing has been vacated. I have received nothing, my lord.
The suit property is the entire property or only the ground floor?
And first floor is using as a
G+1.
What happened after 2017, since our license was not renewed, since the agreement came to an end, we were not getting the license and the doctors used to sit there, they are not sitting.
No,
My lord,
the
paragraph 3 of my
decree was for entire property.
No, it's a 2300 square feet on the ground and
only on the
ground and the first floor.
Ground.
So there are 2 floors, ground
So
floor
the
and first floor.
Is concerned, it is lying vacant.
It is lying vacant, my lord, as per the, my lord, receiver. So, my lord, let them, my lord, give me the first floor.
So first floor is concerned, let them utilize.
But they used as a
And so far as ground floor is concerned, if they want to, my lord, remove those machineries, they need time.
Storeroom, many things are kept there.
I cannot, my lord, suffer at his hand, my lord, after a decree.
We are saying that we will give the vacant now that everything is, but there is no scope for us. So, my lord, since this involves a lot of technicians, my lord, it's a technical work. It's not that we're just lifting some chairs
So
and.
far the first floor is concerned, as because you are not utilizing it, it is remaining
in the
vacant.
first floor, no electricity is there, my lord. I have taken the photographs, my lord.
Take instructions from.
My lord, how can the judgment debtor resist this, my lord, after, my lord?
I'm not, is it resisting?
Or let the receiver take the, receiver is already in physical
Let receiver take, my lord, physical possession and give it to me so far as first floor is concerned. So far as second,
time 2 months, but let the first floor be vacated.
my lord, so far as the ground floor is concerned, my lord, I need.
I have no instructions what is there in the first floor. So,
I have taken pictures, my lord.
You have
That
taken
has,
pictures.
yes, my lord. That has been annexed, my lord. Only broken chairs and broken tables, broken windows, and my lord, one.
The first floor, how many rooms? You have stated in
Yes,
your
my lord. Yes, my lord. I have stated, my lord. One hallway, my lord.
that is page.
Page, my lord. Yes, my lord. On ground floor.
My lord, kindly comes to page 4, my lord.
we can vacate.
No, page 4,
Yes.
second paragraph.
Second paragraph.
After completion of the inspection of the whole ground floor, I proceeded to the first floor. The said property reaching the first floor, I observed that there was 2 rooms and 2 washroom.
Which
And
paragraph?
But
Page
we are
4.
ready
My
to
lord,
vacate.
third
Hand over.
Just a
third paragraph, my lord.
third paragraph.
Yes, my lord. Pardon me, my lord.
You know, that there are 2 rooms, 2 washrooms, and white hall. There is
White
We are
hall,
ready,
there is
my lord. We
no
get the
electricity.
instructions, my lord.
Yes, record.
My lord, kindly hears me for 1 minute, my lord. First floor, they are ready. My lord, I have the ground and the first floor in terms of the decree. I need position. My lord, if they say, my lord, they need permission from the government to remove those machineries which are installed in the ground floor, my lord, they would have to possibly, my lord, secure me for those 2 months, my lord, with the occupation charges. My lord, I cannot, my lord, after getting a decree which is not stayed, my lord, after getting a decree which is not stayed, I am not bothered, my lord, as the decree holder.
Learned advocate for the petitioner decree holder, learned advocate for the judgment debtor, and learned receiver are present. Learned receiver have submitted the report. Mr. Singh, learned advocate for the judgment debtor, submits that as because it was the doctor's chambers and many instruments are there in the room, and necessary permission is to be obtained from the government authority. Considering the peculiar facts and circumstances of the case, Mr. Singh prays for time to proceed in accordance with law and thereafter vacate the suit premises. However, it is submitted that the first floor is lying vacant and the possession can be handed over to the decree holder with regard to the first floor. This court is of the view that at this stage, the receiver take physical possession of the first floor of the suit property and hand over the same to the decree holder on or before 15.
My lord, in next 7 days, my lord, it's vacant.
Can you
Yes, my lord.
There is a long weekend coming. Will, my lord, assist the receiver.
on or before 13/5/2025 and prepare a field note at the time of handing over possession. However, with regard to the ground floor, as considering the peculiar facts and circumstances of the case, the judgment debtor is granted opportunity to make necessary application before the government authority as submitted by the learned advocate and furnish the report before this court on the next date fixed as to what steps is taken with regard to obtaining such permission. However, this matter be fixed on.
One more thing I was requesting, my lord.
Yes.
Since Mr. Singh said that 2 months is latest what he needs to vacate ground floor, let that statement be recorded.
You just make your application, you furnish. I'm keeping it after 1 month. You show me what steps you have taken. Let this matter appear on 10/6/2025.
My lord, for that 1 month period which they are in occupation despite the decree, I am entitled to something. Let them put in, my lord, that 2 lakhs rupees, my lord, as a condition. My lord, I cannot let out the property. No, I cannot let out this. Had this been my property, I would have understand the pain of the decree holder. My lord, the decree holder, despite there being buyers, despite there being persons who are willing to take the property, my lord, cannot let it out. It's a, my lord, the property is built in such a way that the ground and first floor is to be let out to one particular, one individual. My lord, I cannot, despite taking the, my lord, but I am entitled to, my lord, this occupation. He cannot, my lord, resist, my lord, the execution by only saying I have to apply.
Thereafter, if he obtains extension, definitely it will be imposed. Yes, on 10/6/2025, the matter to appear. As a possible matter,
Number 12. In the goods of the Vivash Ghosh,
Yes, not today.
13. Nonparia Dubro. 14. Mrs. Municipal Public House Limited.
My lord, in this matter, my lord, there is a decree which has been passed with regard to amounts which were due and payable by the landlord that was paid by me, the tenant, as advance loans, advance rent. My lord, the landlord had vacated the premises there and by a SARFACCL, the property was sold. Now, the particulars of the landlord which I have, who is the decree judgment debtor. I am the decree holder.
Yes.
I'm the decree holder tenant. I have been pursuing with regard to the amount which has been decreed on account of advance rent paid by me, my lord, and the security deposit towards that. My lord, the landlord has.
Which application?
My lord, it is EC 308 of 2023.
Judgment debtor is represented.
My lord, the judgment letter has not appeared. And my lord, the address I have been trying to serve, the address it is coming back as the judgment letter has left. My lord, the recent affidavit of service may I file, it indicates that there is no such person at this address. My lord, I'm seeking a direction for a police report to be filed in this matter with regard to the address of the judgment letter. I would see that on several occasions I have tried to serve the judgment letter, the partners of the particular partnership firm.
Inquiry can also be made by a special officer to be appointed by this court.
My lord, but the issue is, my lord, they have left the premises. They have sold.
Also take necessary, if they can cause necessary, the special officer can cause necessary inquiry and submit a report. Yes. Learned advocate for the degree holder is present. It is submitted by the learned advocate for the degree holder that in spite of causing service upon the judgment date at the same has returned with the remark that the judgment debtor has left. Learned advocate for the
degree holder
submits that necessary orders may be passed so that inquiry may be caused as to the address of the judgment debtor before passing further orders. In the facts and circumstances, this court is of the view that a special officer may be appointed to cause necessary inquiry about the address of the judgment debtor. There is a partnership firm.
It's a partnership firm, my lord. May I indicate there were three partners.
The address of the partners.
Yes, my lord. I had obtained the addresses.
Address of the partners. Okay, just Dash is appointed as a special officer to cause necessary inquiry and submit a report before this court
regarding the whereabouts of the partnership firm and the partner.
The whereabouts of the partners of the judgment debtors. Such report be filed by 10/6/2025. Even the learned special officer has some difficulties to cause the inquiry, necessary police help may be obtained. Police help and the help from the municipal authorities may also be obtained.
Much obliged, much.
Learned advocate for the degree holder petitioner shall furnish copy of the execution case and necessary particulars of the judgment debtors to the learned special officer.
My lord,
the remuneration of the special officer shall also be owned by the degree holder.
Much obliged.
But yet it is in 18. The matter appear on 10/6. Final
Chamber application actual item number 18.
My lord, this matter was appearing on the top as item number 1 on 1st of May. Your lordship, upon hearing Mr. Thakur, specifically directed that it would retain the same position. Accordingly, Mr. Thakur adjusted his diaries and appearances. It has not appeared today on the top. My lord, let it appear on next Tuesday on the top. Now already 12. This
For the respondent, led by Mr. Shopru.
they have taken adjournment on last
Advocate for the
plaintiff.
plaintiff and learned advocate for defendant. All the defendants.
Only sole defendant.
Are present. On the prayer of the learned advocates, the matter stands adjourned till 13/6/2025. Let this matter appear on
13/6.
13/5/2025. Let this matter appear on 13/5/2025
At the top. Deeply organized.
list of my lord Justice Mojumdar, my lord, which I understand has been assigned before your lordship.
Yes.
My lord, it was in my lord item number 4 in the list of Justice Mojumdar. The interim order is till today.
Item 4.
Item number 4. 5.
Item number 5. Yes, specially assigned matters.
Yes.
Item 5.
Item number 5. The interim order is till today, my lord. I was praying for my lord, kindly extend it, my lord, for some time so that Friday being holiday, kindly extend it.
Both sides are here.
Yes,
Yes, please record an order.
A limited extension
Learned,
because the matter is being heard.
learned advocates for the parties are present. Considering the urgency of the matter, it is taken up for consideration. Hard learned advocates, as the interim order, which was granted when?
my lord, the interim order was originally granted by your lordship on 1st of June,
Okay.
2023.
Interim order.
And last
Okay.
extended, my lord, on 28th April 2025.
Interim order, which was granted on 1st June 2023 and extended from time to time, is going to expire today.
Lordship, my lord.
Thus, this said interim order stands extended till.
You kindly make it till Tuesday because the matter will again appear in the list tomorrow if his lordship sits.
Very well. Tuesday or, my lord, kindly give it, my lord, till the end of that week. We shall try to get it, my
Okay,
lord.
extended till 16/5/2025.
But kindly indicate that the matter may appear in the list of his lordship.
Oh, it is appearing.
It was appearing today, but
It is appearing. It will retain. Yes, no, actually,
let the matter retain its position.
that would not be proper to pass that. Whether the matter will remain there or go somewhere.
My lord, may I take a leave to mention for inclusion of my lord the suit? This is the old suit, my lord.
Old suit, yes.
Much of.
May I be permitted to mention one matter, my lord? With the liberty of this honorable court, I filed my vakalatnama in a suit, my lord, for one plaintiff. But yesterday evening, my lord, I am going through the status report of some other cases. I found that the suit has been withdrawn by the order dated 2nd May 2025. Immediate, I filed my vakalatnama on 25th of April. Immediately, I served the notice to the erstwhile advocate of the all plaintiffs, my lord. I have the copy,
Okay,
my
let
lord.
it appear as
Immediately.
to be mentioned.
To be mentioned on 8th, my lord. On 8th.
To be mentioned on 8th.
I'll serve notice to all
Yes.
three.
May I permitted to mention before your lordship?
It
I intend to file one vakalatnama, lordship, in connection with the PLA matter that is still pending since 2007.
Yes.
Lordship, kindly allow me to file the vakalatnama on the behalf of respondent number 3 and 4.
Under compelling circumstances, my lord, I am praying for a leave to file a matter, my lord, on 7th, my lord, your lordship passed an order. There was an order for upon the sheriff. Your lordship has directed given time till 7th. Ask the sheriff to visit the premises after 7th, my lord. Now, in the meantime, the other owners and the property holders, my lord, they want to approach the appeal court unless they file before your lordship, my lord.
Question is, I have made it clear that you can appear up. That means the belief is
My lord,
permitted.
unless we get an order from a single bench, my lord, I cannot go before the appellate court, my lord.
No. Question is, you are a party here.
Not, I am not a party over here, my lord. We are filing for.
Yes.
My lord,
serve
we are
notice.
praying. We are praying for a leave to file application. We will serve notice upon that.
Okay,
my lord.
leave to file.
Leave to file, my lord. That's why.
Yes.
Let the matter appear, my lord, tomorrow because 7th is the date, my lord. That's we are.
This is your what, affidavit?
No, my lord.
we are filing an application affidavit in the form of affidavit with regard to as a sub-lazy, my lord. Sub-lazy.
That is 8th. Let it appear on 8th.
My lord, because 7th, after 7th, your lordship has directed.
Let us see on 8th what happens.
My lord, if it can be tomorrow, my lord.
Today is 6th. Okay. Let
Yes,
us
my
see
lord,
what.
my lord.
Let us see up to 8th what happens. If there are some developments, the court will consider.
My lord, since
yes, serve notice.
We'll serve. Leave to the hearing. So,
To be mentioned, item number 2, Sri Hanuman Jute Mills.
তো কিন্তু কিছু ক্লারিফিকেশন এটা কি ডিসপোজড হিসাবে দেখানো হয়ে গেছে এটা পেন্ডিং দেখাতে হবে আচ্ছা রেকর্ড অ্যান্ড অর্ডার the matter is put up for necessary clarification and rectification as the matter is shown as disposed by the department, let necessary rectification be made and the matter be treated as pending.
New motions, item number 19, Kantimoy Kundu Chaudhuri and others.
This is my application. Your Lord, an interim order was passed, my lord, earlier restraining the third parties from disturbing possession of my land.
Yes.
But it was passed earlier, it was extended from time to time. And thereafter, my lord, it lapsed and then it was reimposed on 6th March for 8 weeks. That is expiring today.
GA has to be heard out.
Yes, it has to be heard out. Lord, my application direction was passed for filing affidavits, but I have not received any affidavit yet.
Yes.
I am for joining, sir. I will file. Every opposition, my lord, kindly extend the time for opposition, my lord.
Yes. Learned advocate for the petitioner, decree holder, and learned advocate.
No, not decree holder. I am a third party to the proceedings.
Okay, learned advocate for the applicant intervener,
yes,
and learned advocate
for
the joint receiver are present. As affidavits is not filed by the joint receiver and prayer for time is made on his behalf, on their behalf, the time to file affidavit stands extended till 20th May 2025.
Some more, my lord.
On the reopening date, 9/6/2025. Reply, if any, by 13/6/2025. Let this matter appear on 16/6/2025.
The interim order may be extended.
The interim order passed earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
But till the returnable date, if your lordship kindly make it.
I'm making it 6 weeks.
Very.
It will be covered.
Will come. Yes. Grateful.
I'm grateful.
Item number 20, Bhupesh Kumar Mahawar.
And I appear for defendant number 9B. Lord, this is my lord, first introduction, my lord, to this matter. My lord, I am, my lord, the intending purchaser. I'll tell your lordship, my lord, why I am here today. My lord, I have been told, my lord, this is a.
So you're for.
I am for the plaintiff.
Plaintiff.
There is a suit for dissolution of a partnership firm.
Yes.
And for partition of the assets of the firm.
Yes.
Now there are several properties of the firm scattered throughout the country.
Yes.
In state of Rajasthan, Uttar Pradesh, everywhere. Now there are immovable properties as well as plant and machinery.
Yes.
So what had happened is the preliminary decree has already been passed and joint partition commissioners and receivers were appointed. Now these joint receivers were directed to carry out a valuation of the properties and invite publish advertisements inviting bids for sale. That has been done. Now this my learned friend possibly is for a purchaser who had purchased one of the properties which was put up for sale. Sale was confirmed, but there was a time limit given within which he had to make the payment. Which time limit they have not yet complied with. So they are out of time. So that is why
Hearing for the first time now, my lord. I'll tell your lordship, my lord, orders as indicated by Mr. Gupta, my lord, orders have been passed, my lord, in this, my lord, suit, wherein, my lord, initially, my lord, an order was passed for, my lord, valuation of, my lord, the property. Thereafter, my lord, the valuation was done. No objection was there. Thereafter, my lord, the joint receivers who were, my lord, appointed in this suit had, my lord, made paper publication of those, my lord, assets. My lord, I had, my lord, put in my bid, my lord, along with the other, my lord, bidders. I was, my lord, the highest bidder, my lord, in respect of a property in Rajasthan, a flour mill in Rajasthan. I was, my lord, the highest bidder. My lord, thereafter, my lord, after I had put in the, my lord, earnest money deposit of 10 lakh rupees, my lord, the sale was, my lord, confirmed in my favor by, my lord, the joint receivers, and that has been recorded in one of the orders. If your lordship kindly takes that order first, 6th of January 2025. To the book. My lord, these are, my lord, the bunch of orders which I have been able to obtain from one of the website. Your lordship kindly takes page 7. 6th of January 2025. Yes. Your lordship will kindly take internal page 7 of, my lord, that order. Yes. Running page কত? এখানে পাবি না running page 13. Running page 13, my lord. My lord, under the heading, my lord, GA 18 of 2022. Running page 13, my lord. Yes. Peruse the report of the joint receivers. It is found that one Mr. Kamalesh Sharma, this will not be Mr. Kamalesh Sharma, appearing at serial number 11 is paragraph 3 of the report, has bid the highest amount, highest amounting to rupees 27 crores 75 lakhs. Accordingly, the sale of the properties in question is confirmed in favor of Mr. Kamalesh Sharma of 1/101 such and such. The learned joint receivers are directed to refund the demand draft of the other 10 bidders of rupees 10 lakhs. Learned joint receivers are granted liberty to deposit the amount of rupees 10 lakhs in their account deposited by Mr. Kamalesh Sharma, whom I am representing before your lordship today, under serial number 11. Mr. Kamalesh Sharma is directed to deposit the entire balance amount of the offer price within 1 month from the date of communication of the order, failing which confirmation of the sale in favor of Mr. Kamalesh Sharma shall lapse. And thereafter, the joint receivers were directed to communicate the order. And upon deposit, a sale deed to be executed in my favor. Now, my lord, if your lordship kindly takes, my lord, the order of, my lord, 10th of February 2025, which is at, my lord, page number 1, running page number 1, kindly takes again GA under the heading GA 18. Yes. Internal page number 5 of that order, my lord, which is at, my lord, page number running page 5. The instant application is treated as it on in the days list on the prayer of such and such. My lord, kindly sees, my lord, is modified to the extent that the time period for depositing the entire balance amount by the party Kamalesh Sharma, in whose favor sale has been confirmed, is extended for a further period of 6 weeks from the date of communication of this order, failing which the confirmation of sale in favor of Kamalesh Sharma shall lapse. It is page 5. This is, my lord, page 5. My lord, under the heading, my lord, GA 18 of 2022. Yes. My lord, I am reading, my lord, the second paragraph. On the prayer of Mr. Gupta, learned advocate for the applicant, the order dated 6 January 2025 is modified to the extent that the time period for depositing the entire balance amount by the party Kamalesh Sharma, is in whose favor sale has been confirmed, is extended for a further period of 6 weeks from the date of communication of this order, failing which the confirmation of sale in favor of Kamalesh Sharma shall lapse. Thereafter, an inadvertent typographical error has crept in the order dated 6th of January 2025, mentioning the name of the highest bidder, Mr. Kamalesh Sharma, instead of Kamalesh Sharma. There will not be any Mr. in that, my lord. I am representing Kamalesh Sharma. Is a lady, my lord. The name of the highest bidder in the aforesaid order to be read as Kamalesh Sharma instead of Mr. Kamalesh Sharma. Now, my lord, interestingly, my lord, if your lordship now, my lord, takes, my lord, the order of 10th January 2025, why I have not been able to, my lord, complete the sale, or rather, my lord, put in the balance money, is because
How much
of
you are required to pay?
My lord, I am required to pay, my lord, 27 crores 75 lakhs, out of which 10 lakhs I have paid as my earnest money deposit, which has been accepted and sale has been confirmed. Now, my lord, there is no other bidders which is, my lord, prevalent right now, my lord, before your lordship, my lord. I am the only one who is present as who is the highest bidder. Now, if your lordship kindly sees, my lord, page 1 of my lord, the order of my lord, 10th of February 2025, your lordship will find, my lord, one applicant, my lord, really, my lord, the defendant number 9A had filed an application. Kindly turns over the page, my lord, page 2. Your lordship will find that Mr. Gorai, my lord, had learned advocate appearing for the applicant submits that on 20th December 2024, the civil judge and judicial magistrate Rajgarh, District Alwar, has passed an order of stay to keep the status of the plot as it is and not to transfer the disputed property to anyone else. As such, the joint receivers be restrained from proceeding further with conveyance of the property in question in favor of Kamlesh Sharma till disposal of the application. Now, my lord, your lordship will find that this order was, my lord, finally, my lord, this application was finally dismissed. Your lordship will find that, my lord, at, my lord, page, if your lordship kindly sees, my lord, page 5 of, my lord, the compilation, your lordship will find that apart, the application does not contain the copy of the order passed by the learned civil judge judicial magistrate, if any. Further, the form annexure E clearly records that the same is an information to the applicant and cannot be used as a witness in any court. In view of the above, this court finds that the application is bereft of particulars and hence does not merit consideration. Accordingly, the application, which is the application of the defendant number 9A, stands dismissed. Now, my lord, the difficulty is that I'll tell your lordship kindly allows me for one more minute.
I've already.
My lord, I'll tell your lordship, my lord, exactly, my lord, what is my impediment from completing the sale, my lord. My impediment for completing the sale is that, my lord, there is a list pendants. My lord, the suit is, my lord, this was not there. This was not brought to the notice of, my lord, the intending purchaser whom I am representing, I'm sorry, not Mr. Kamlesh Sharma, whom I am representing. So, my lord, this impediment, my lord, if, my lord, your lordship, my lord, kindly permits me, my lord, some more time to, my lord, complete the sale till such time, my lord, this suit, my lord, whatever happens or result or the fate of the suit, I have been told, my lord, this, I have been only instructed, my lord, that this order which was there prevalent at that point of time, which is my learned friend's contention, which copy of which was not even produced with the application, has now been vacated. That is my instructions from my client. But
26th of February.
now, my lord, if that had been, my lord, vacated, the only impediment now is perhaps, my lord, the suit which is, my lord, pending, which has been filed subsequent to, my lord, confirmation of sale in my favor. Absolutely frivolous suit, my lord, perhaps in my respectful submission should not have seen the light of the day. But, my lord, be that as it may, it has now been, my lord,
application GA 25 that was dismissed.
That was dismissed.
My lord, we have preferred an appeal against this.
Yes. What is the stage of the appeal?
My lord, yes, yet to be listed.
Not sir. Not sir.
Mr. Sarkar, I am appearing on behalf of the receivers who had not been directed by this honorable court to will not instrumentalize and give effect to the same. Where Mr. Sarkar's client appears to be the highest bidder.
Yes.
The Lordship has been shown the order of 10th of February. May I kindly invite your Lordship attention at page 4 of the 10th February order.
Yes.
After the from the sentence which begins with therefore, your lordship has it. Therefore, from the aforesaid chronology of facts, it appears that the application seeking direction for sale of properties of the partnership firm was initiated in 2022. Thereafter, upon consideration of the valuation report, publication for sale was made and bids were submitted. Upon considering the report of the joint receiver, the sale has been confirmed in favor of Kamlesh Sharma. The order passed by the civil judge and judicial magistrate Rajgarh on 20th December 2024 as contended is much later to the order passed by this honorable court in this proceedings. Upon inquiry by the court, the learned advocate for the applicant fails to apprise us as to whether the learned civil judge and judicial magistrate was informed of the series of the orders passed in the proceedings for sale of the property in question. The next page. That apart, the application does not contain the copy of the order passed by the learned civil judge. Further, from annexure E, clearly records that sale is an information to the applicant and cannot be used as a witness in any way. In view of the above, this court finds that the application is bereft of particulars and hence does not merit consideration. Accordingly, the GA was dismissed and the joint receivers is directed to communicate this order to the learned civil judge and judicial magistrate Rajgarh Alwar as well as Tehsildar Rajgarh municipal authorities of respective zones, district and sub-registrars of the respective districts, local police stations where the properties are situated.
So that has been done.
And below the two receivers, they not only physically visited, but they were physically present when the hearing took place. And that particular order, where was an embargo created in the property, has been vacated. May I hand up? It is
So have you served a copy?
Yes, served to the plaintiffs. I am carrying copies. I will give it right. Correct. In the Hindi vernacular, page 4.
Page 4.
I'm assuming your lordship can read better than me. I don't think.
When you read out.
Difficult.
Paragraph 4.
Page 4, the portion I have marked. And I have marked on the right hand side. Right hand side in the middle, I have marked with black ink.
মাইক্রোফোনে চলে
আপনি অমাইক জানেন
आज रिसीवर की ओर से प्रस्तुत शपथ पत्र में भी जाहिर किया गया है
Just a minute. Page 4, middle.
I have marked it
with page 4. आज रिसीवर के ओर से.
Yes, आज रिसीवर की ओर से प्रस्तुत शपथ पत्र में भी जाहिर किया गया है कि माननीय कलकत्ता उच्च न्यायालय ने अगस्त 2, 2024 को पक्षकारण को वादग्रस्त संपत्ति को बेचान हस्तांतरित नहीं करने का आदेश प्रदान किया था। उक्त तथ्य प्रार्थीवादी अथवा प्रतिवादी द्वारा न्यायालय के समक्ष दिनांक 18/12/24 को की गई बहस अंतरिम निषेधाज्ञा से समय न्यायालय के समक्ष उजागर नहीं किया गया था। हस्तगत प्रार्थना पत्र के जरिए प्रार्थी प्रतिवादी संख्या 2 आदेश 39 नियम 4 सीपीसी के अंतर्गत अपराधीवादी द्वारा प्राप्त अंतरिम स्थगन आदेश को निरस्त करने का अनुरोध किया गया है। साथ ही प्रकरण के द्वितीय वाद पोषणी नहीं होना चाहिए जाहिर किया गया है। द्वितीय वाद के पोषणी नहीं होने के संदर्भ में मूल पत्रावली के धारा 10 सीपीसी का प्रार्थना पत्र के जवाब के स्तर पर लंबित है। इस संदर्भ में हस्तपद प्रकरण की संक्षेप में पृष्ठभूमि का अंकन किया जाना आवश्यक है।
Page 5, the last 4 lines.
लास्ट 4 लाइन
Yes, आवेश सुनाया।
अतः उपरोक्त समस्त तथ्यों को ध्यान में रखते हुए प्रार्थी और प्रार्थना पत्र अंतर्गत आदेश
लास्ट फ्रॉम द बॉटम
लास्ट फ्रॉम द बॉटम मतलब 5 लाइन्स। अतः उपरोक्त समस्त तथ्यों को ध्यान में रखते हुए प्रार्थी एवं प्रार्थना पत्र अंतर्गत आदेश 39 नियम 4 संगठित धारा 151 सीपीसी स्वीकार किया जाकर न्यायालय द्वारा पारित अंतरिम आदेश दिनांक 18/12/24 को निरस्त किया जाता है। आदेश सुनाया गया है। प्रकरण की मूल पत्रावली के साथ 10 सीपीसी का प्रार्थना पत्र लंबित है जिसमें पक्षकारण को जवाब बहस के निर्देश दिए जा चुके हैं। पत्रावली अग्रिम कार्यवाही के मूल दावे को 27/2/25 को पेश करें।
So, it has been vacated. The joint special officers who were appointed has successfully complied with the directions of the court. I do not.
So according to you, there is no bar in the property being alienated. Anyway, sale is already confirmed. Possession is yet to be handed over.
Payment has not been made. Question of handing over a possession.
No. Sale is
confirmed. I'll tell you, Lordship.
Sale is confirmed.
Yes.
Now the question is upon making the payment.
Yes.
Now, my lord, my
purchaser can take the possession.
My lord, I appear for the purchaser. My lord, I also have to look after, my lord, whether I'm in what state I'm getting the property. Now, my lord, because of this suit, my lord, which is why, my lord, really, my lord, which has, my lord, hindered my way to, my lord, complete the sale. So, my lord, this is, my lord, what is, my lord, the impediment because of, my lord, 52A, my lord, lis pendens, which is, my lord, coming in the way because a suit has been filed in, my lord, during the interregnum period, my lord, when, my lord, the sale was confirmed. In fact, my lord, after the sale was confirmed. So, my lord, which is the impediment?
There
which
is no order.
I have, my lord, I'll
So
tell
there
you.
is no order challenging the confirmation of sale.
My lord, as I'm not intending purchaser.
No, the sale
entire order.
But there's
confirmation of
only
sale.
from the bar. That's a statement from the bar. There is no document. The document is not there. My lord, I do not know.
Check the case status. Appeal filed on 27th March. Not yet served on us. No attempt made to move. And now they are trying to stall something.
No, I've just indicated.
So
that
kindly, kindly do not give them any credit.
No, I have just indicated that I've preferred an appeal against that order.
If your lordship, my lord, kindly gives me, my lord, some more time to, my lord, complete the sale. I want to, my lord, purchase this property. My lord, there is no two doubt about this, my lord. I have been, my lord, the highest bidder. The sale has been confirmed. I want to purchase it. The only impediment is, my lord, the list pendants, which has been created, my lord, subsequent to my lord, confirmation of sale. That is
Anyway, you have to make out your mind. So if you want, you have to pay the amount.
My lord, your lordship kindly gives me, my lord, some more time. I'll also take instructions to that effect, my lord, whether, my lord, with this, my lord, can I go ahead with this? I do not know, my lord, there cannot be any conditional sale, but, my lord,
Lord, may I make one humble suggestion? But we as plaintiffs and the parties to the suit who will all gain if the properties are sold, we do not want to let go of it.
No,
But
who
at
has
the same
instituted the suit? Any third party?
No, I have filed the suit.
No,
that
no.
suit between third parties.
That is neither of the parties.
Parties to the suit. No, none of the parties to the suit are arrayed as parties in that. But a property which is a suit property was sought to be included in that.
Oh,
No,
neither
what
of the parties are implicated there.
But may I make one humble submission subject to what falls to my lordship? But if my learned friend's client can give an affidavit indicating by which time they can make the payment, and on that basis, your lordship may extend the time to make the payment, because otherwise the submission is coming from the bar. So, let them put it on affidavit, and thereafter your lordship would kindly consider. Because the time, we do not want them to go, because now all the other bidders have gone. We received the special officers received 11 bids. 10 bidders who were unsuccessful, their earnest money have been returned to them. So, if he goes or she goes, then we cannot.
Anyway, let him take some time. Okay.
Thereafter, I am not standing.
No, thereafter we shall submit an affidavit.
my lord, I can do, my lord, one thing. My lord, what has been, my lord,
next day.
I'll tell you, lordship, my lord, what has been proposed by my learned friend, my lord, perhaps, my lord, will come anyhow to everyone's benefit. But I'll also take instructions. Your lordship may kindly give this direction, affidavit, or, my lord, any kind of letter, if any, my lord, stating that, my lord, we are now, my lord, also, my lord, willing to, my lord, take the property, and, my lord, under what conditions?
Yes.
My lord,
Lord, there is one more aspect, my lord.
application which is today
Lord, there is
listed.
one more aspect, my lord, prior to, my lord.
I appear for 9B. I'd like to use an affidavit.
My lord, there is one more aspect to this, my lord, prior to your lordship, my lord, dictates the order, my lord. My lord, the Tehsildar, my lord, of, my lord, the concerned, my lord, district, Alwar in Rajasthan, my lord, may he be directed to, my lord, conduct a survey of, my lord, the land, so that the exact measurements of the land can be, my lord, known to, my lord, the intending purchaser, my lord. Only to that extent, my lord.
Not at this stage. Okay, you come after some other time.
Very well.
Learned advocate for the plaintiff. You are for learned
9B.
For defendant number
Defendant 9B.
9B, learned advocate representing the joint receivers and learned advocate appearing for the applicant purchasers are present. It appears that by order dated 10th February 2025, passed in GA 25 of 2025, the purchaser was granted time for a period of 6 weeks to pay the balance amount of the consideration money to confirm the sale. Upon perusal of the report submitted by the, it's not a report, it's an order.
Yes,
It is upon perusal of a copy of the order dated 25 to 2025, passed by the learned. This is civil judge?
Yes, this is the civil judge.
Yes, civil judge and judicial magistrate.
Yes.
Rajgor Alwar. It appears that the interim order which was granted with regard to the suit property is already vacated. learned advocate for the intending purchaser submits that due to the pendency of the suit, he was unable to deposit the balance amount of consideration money. Learned advocate for the defendant number 9A submits that an appeal is already preferred against against the order dated 10th February 2025, passed in GA 25 of 2025. But however, there is no stay of further proceedings in this case. Learned advocate for the plaintiff also suggests that the intending purchaser may file an affidavit to clarify as to within which period he is ready and willing to pay the balance amount of consideration money. Upon considering the submissions of the learned advocates and considering the facts of the case and the grounds furnished, this court is of the view that some further time be granted to the intending purchaser to take necessary steps. Thus, this matter stands adjourned till 11/6/2025.
After 11th, till 11th, 12th or 13th.
12/6/2025 to enable the intending purchaser to take necessary steps and filed an affidavit on the next date fixed.
I'm
Well,
grateful. GA 26, the
GA
matter
26,
which is listed.
I'll move tomorrow. Kindly do not take up GA 26.
No, I was only
And-
seeking for an affidavit direction.
I would say he has no right. Let us come back tomorrow.
I'm a
on
party
GA
to that proceedings. Well, today it is listed.
Let us come
GA
back to
26.
GA is the other is
GA 26, which is listed today.
okay. Let GA 26 of
Tomorrow, day
2000
after.
Well, GA 26
GA 26 of 2025
25. Well, I'm just praying for an affidavit direction.
be put up on 8/6/2025.
8/6.
8/5/2025.
Well, let it be on the other side of that.
Well, I have a very nervous spread. That's why I'm not.
Calcutta. Well, Lordship will kindly keep.
Lordship has successfully complied the order.
আচ্ছা এখানে করে 9 তারিখ মানে ফেরত আছে কোন না এই 9 তারিখ বলছে ওইদিকে কোন না 13 তারিখে করে না
And authorities which the court directed them. They stayed at the place.
What is it?
The remuneration has not been decided on.
Any initial remuneration was paid. Okay.
He is not there on the 8th. Could it be on the
But
7th?
Lordship will kindly clip it on 7th or on 13th or on 13th.
13th?
13th.
Yes, 13th?
Yes,
13th.
Okay, just a minute. 13th, huh? It is as the learned receivers were paid remuneration a long time back, both joint receivers, let further remuneration of 6,000 GMs to be shared by the parties be paid to the joint receivers.
There is a common fund. Like, can they be permitted to withdraw it from the common? They are the signatories.
Okay. As submitted, the said amount can be withdrawn from the common fund, and a report be submitted to this effect. Yes, on the next date.
Yes, enclosing the order and the other.
Yes, submit a report as to the amount withdrawn.
I'm grateful. Great.
Hello.
Yes. 2 p.m. 2 p.m. fixed matter.
শুনুন তো একটু ডেকে দে তো।
But I appear for the plaintiff, where I was cross-examining the witness, only but the fag end of that cross-examination only.
Cross-examination of DW.
DW2.
DW2.
But may I just tell your lordship what is the fact about, so that it can be easier for your lordship, my lord, to ascertain. My lord, it is a suit for specific performance of an agreement for sale of a flat and a garage space in a premises. Payment was made, possession was given, but conveyance was not done. So that is why the application, why a suit was filed for execution of the conveyance. In fact, there were two agreements, one by the husband and another by the wife. The wife's, as far as the wife's suit is concerned, that has been disposed of. Conveyance has been executed by the registrar of conveyance, registrar of this honorable court, and the husband's suit is pending. Now, that is what your lordship is now hearing.
Yes, that
But
is-
only few questions are left. I will just ask
That is DW2.
DW2. He is already on oath. Convinced about convinced.
Yes.
Witness, you said that you were acting as an accountant of the defendant for certain point of time. You don't nod your head. Yes. or no? Yes. And in course of your tenure with this defendant in the capacity of an accountant, so you had also occasion to know that they simultaneously with the transaction with the husband, Kinam, Rajkumar Agarwal, his wife Shoshi Devi Agarwal was also having an agreement to purchase the flat and the garage. Yes, and garage.
Maybe.
And you are also aware that conveyance has already been executed in favor of Shoshi Devi Agarwal in respect of the flat and the garage by the registrar of this honorable court. You are not aware of. Very well, you may not be aware. I am not aware of. You are aware about the monetary transaction which had taken place in connection with the sale of that flat and the garage to Shoshi Devi Agarwal by the defendant. All the account paycheck checks. Yeah. Account paychecks. And if I show you those checks which you have just referred to, you would be in a position to identify that. Thank you. Now, I am showing you a document being exhibit G in this proceeding, which is the registered deed of conveyance executed by the registered original side of this honorable court in favor of Shoshi Devi Agarwal. Kindly look at the schedule of that conveyance. G. It is at page 16. একটু বার করে দিন ওনাকে। Yes, 16:16. Now, do you find the reference of the flat and the garage space and their respective measurement in the schedule of this conveyance? Yes, yes, all right. Now kindly come to page 18 of that schedule of that conveyance. You will
He is
find
the accountant of the defendant. So he will have knowledge with accounts transaction.
that's right. This is the part of the account.
This is the part of the accounts
Yes.
transaction. Yes.
Now kindly look at the first three check particulars of the checks. It was given in favor of RC Estate Private Limited. Isn't it so? Yes, I am showing it from the record. Whether you find it or not, you kindly tell my lord. Is a part of the conveyance. You need not. It is a part of the court's record. You kindly see whether you find the check, three checks from the first three checks drawn on Allahabad Bank in the name of RC Estate Private Limited, and the check number kindly sees 613, 614 and 625. Do you find that? And the figure mentioned against these three checks are respectively 1 lakh, 1 lakhs and 2 lakhs. Yes. So, and the total consideration shown in this schedule is 21 lakhs. Yes. So, therefore, from this deed of conveyance, we find that the total consideration for this flat and the garage was 21 lakhs. Yes, yes, it is part of the court. Part of the court. Right. Now, in this suit, in the present suit, the suit by Rajkumar Agarwal being the husband of Shoshi Devi Agarwal, the defendant has filed a written statement. Kindly look at that written statement once. No, not this one. This is done. My lord, may I show him the written statement, original written statement?
This is the original.
Yes.
No, this. Yes, yes, yes.
May I show him? Kindly come to annexure A to this written statement. Page 12 maybe. I do not know. You will find that several check numbers are mentioned in this page by the defendant, saying have received from the plaintiff towards the consideration of the flat and the garage. Do you find that? Details? Yes, yes. Now kindly see the last three checks dated 3rd May 96, 6th May 96 and 12th June 96 respectively. Yes. And these check numbers is 103613, 103614 and 103625. And the figure mentioned against these three checks are 1 lakh, 1 lakh and 2 lakhs respectively. Yes. Now kindly take the conveyance which was looking after you by you being exhibit G. Exhibit G. At page 18. Now find the last three checks are same checks as shown in the written in the schedule in annexure A to the written statement. ওটা কেটে দিন, ওটা পড়ে দিন না, কোশ্চেনটা পড়ে দিন না, তাহলেই তো হলো। আমি বুঝিয়ে দিচ্ছি ওনাকে, আর পড়তে হবে। এই যে তিনটা চেক এখানে ছেড়ে যাই বলে দিচ্ছি, এই যে শিডিউল যেটা এই যে ডান হাতে যেটা ধরে আছেন এটার যে লাস্ট তিনটে চেক নাম্বারস, হ্যাঁ লাস্ট 3 চেক নাম্বারস আর এই রিটেন স্টেটমেন্টের অ্যানেক্সচার এর লাস্ট তিনটে চেক নাম্বারস আর সেম। হ্যাঁ ওই লাস্ট তিনটে ফার্স্ট তিনটে আগে পরে হচ্ছে হয়তো লাস্ট তিনটে ইয়েস আইডেন্টিক্যাল very well. I put it to you, the witness, I would say, put it to witness, in the written statement, these last 3 checks which was shown by the defendant are the checks given to the defendant relating to the transaction between defendant and Shashi Devi Agarwal, which was the subject matter of suit number 347 of 1999. অর্থাৎ এই যে তিনটে চেক দেখানো হলো এই তিনটে চেক অ্যাকচুয়ালি শশী দেবী আগরওয়ালকেই অ্যাকাউন্টে দেওয়া হয়েছিল, সেটা ওই এর থেকে দেখা যাচ্ছে। But it's shown from the written statement. আমি আপনাকে সাজেশন দিয়েছি। I have given it to you.
The suggestion or a specific question?
কিভাবে করেছি এটা? কি প্রশ্নটা শুরু করেছি?
সাজেশন।
হ্যাঁ সাজেশন।
What is your suggestion?
দশ সাহেবকে পড়ে শুনিয়ে দেবো।
Yes, you repeat.
আস্তে আস্তে বলো। It is বলতো ওইটা and Shashi. And as shown in the conveyance, being exhibit G. Exhibit G যেটা আপনি ডানাতে ধরে আছেন।
Anyway, record that.
And of course, well, of course.
That I am not aware.
But
filed by
defendant.
Is from the books of
Yes, record it. No, the answer was specific, whether you are aware of that or not. Okay. Very well. That much will go.
Very well. Now, very well. You are giving the right answer. Witness, you may not be aware of the transaction which had actually taken place, but kindly look at these 2 documents side by side and tell my lord whether the last 3 check numbers in exhibit G are the same check numbers in annexure A to the written statement. Yes or no? এটা আগে পড়ে হচ্ছে ফার্স্ট, বলে দাও না, বলে দাও। That is
yes.
That's okay. Thank you. Give it. I put it to you that these 3 checks which have been shown in the schedule of conveyance being exhibit G, being check number 103613 103614 and 103625 were duly encashed by the defendant, which would be evident from the defendant's bank statement. Whether no, it was encashed, and that would be evident from the defendant's own bank statement. Yes.
Yes.
These checks were encashed.
Yes.
আর তো দেখাবার দরকার নেই। দাও বেশি প্লেনটা দাও।
No, question is whether there were encashed or not. Okay. Very well. That only.
That is the question. এটা কি দেখাবো? আর দেখাবার কি আছে? দাও। হ্যাঁ, একটুখানি হয়ে যাচ্ছে। The last one or two questions. কি আছে এখানে? মেনে নিজ আর কি বলার কি দরকার আছে, এটা রেখে দাও। The witness কোন স্টেটমেন্ট তো মুঝে বলছে তো ইন্টারেস্ট witness I put it to you that the oral agreement which had taken place between the plaintiff and the defendant for sale of the first floor flat and a garage space, 2 garage spaces in the suit premises, were agreed to be sold at rupees 21 lakhs. 20 lakhs.
Okay, not a fact.
30. Do you have any document to show that there was any such agreement of rupees 30 lakhs as the consideration of the any agreement?
No, previous question, did you record previous question?
Yes, recorded. Yes.
Not a fact.
Do you have any record to show that the plaintiff and the defendant agreed to buy the flat at rupees 30 lakhs?
No, question is, do you have any documents that? Yes.
That is it. I put it to you that only upon I put it to you that the plaintiff had fully paid the consideration of 20 lakhs by checks, and there was nothing due and payable on such account to the defendant.
Anyway, not a fact. It will be.
Not a fact. On what basis you are saying so? Now, after you had accounted for the checks, how could you know that the consideration was of rupees 30 lakhs, not 20 lakhs?
No, from which document you came to know that the. Okay, I just came to know from instructions. Okay, yes, that should be recorded.
Junior accountant?
Yes, I came to know from instructions.
So apart from this oral instruction, you did not have any record to show that the agreement for rupees 30 lakhs was made between the parties.
No, question is whether apart from this oral instruction, did you see any document? Yes.
Now, you know, at any point of time, after the possession of the flat and the garage was given, any demand was made by the defendant for payment of the balance sum of rupees? The balance sum?
Yes.
So, do you have a record to show that any demand was made at any point of time? I put it to you. Did you have yourself seen any record? You say that to my lord.
Yes.
Yes, sir. The evidence which you are giving is Mr. No, not the full name. Your name. Only the person. Daga. Yes. The evidence which you are giving, Mr. Daga, regarding this alleged monetary consideration of rupees 30 lakhs, have got no basis.
Okay, not a fact. Okay.
This is also incorrect, Mr. Daga. This is also incorrect. This is my suggestion that your evidence that there was an agreement for sale of the flat and the garage space at rupees 30 lakhs. এটাও ভুল মিথ্যে কথা Yes.
Anyway, not a fact.
Not a fact, not a fact. আর কিছু বলার আছে? Well, that's all.
That's all. Any other witness? Defendant?
Yes.
Any other witness to be adduced?
Yes.
Yes.
তো ম্যারাথন চলবে রে
বেশি দিন ওটা একদিনই হয়ে যাবে একদিনই
Yes, record and order.
একজন
Learned counsel for the plaintiff and learned counsel for the defendant are present. DW2 is present in court. Cross-examination of DW2 is complete and DW2 is discharged on the prayer of learned advocate for the defendant. Let a date be fixed before vacation?
No, my lord, after vacation. He's an aged person.
Aged person?
Yes, my lord.
You want to bring him to court or do you want to do it by commission?
No, he will come.
Okay. Let this matter appear on 12/6/2025. Yes, 12/6/2025.
Lord, can we go to the next week? After
following week.
12. After 12.
Okay. 17/6/2025 at 3 p.m.
At 3. Obliged. Thank you, Mr. Daga.
My lord, this is my affidavit of service and notice of motion. My lord, I have made one application for withdrawal of my lord exhibited documents, my lord, original that was cited by the defendant number 2 at the time of the evidence, my lord.
You are appearing for?
I am appearing for the defendant number 2.
Okay. The suit
Lord,
is
the defendant
disposed.
number. It was disposed on 15 December 2014 based on the compromise. It was a partition suit based on
The suit is
compromise.
finally decreed.
Finally decreed. My lord, defendant number 2 wants to withdraw, my lord, original documents that was exhibited as exhibit 1 and 2.
Yes. Give the petition. এটা the notice of motion
বলেছি
notice of motion নেই
my lord, certified copy of the original.
Affidavit of service ওর মধ্যেই
I have given my lord.
affidavit of service এর মধ্যেই থাকবে ওটা Yes, record and order. Learned advocate appearing for all the defendants.
My lord.
For the defendants is present. This is an application for withdrawal of the original exhibited documents being exhibit 1 and exhibit 2. Is the contention of the petitioner that the suit is disposed by passing final decree on December 15, 2000.
Defendant number 2, my lord. Defendant number 2.
Learned advocate for the defendant number 2 petitioner is present. The suit is finally decreed on compromise on December 15, 2014, passed by the Honorable Division Bench comprising Justice Banerjee and Justice Ashish Kumar Chakraborty. It is further contended that the defendants undertake to return the original documents as and when required. As the suit is disposed on compromise and there is no appeal pending, the prayer of the petitioner defendant should be allowed. Thus, let there be an order in terms of the prayer made in the notice of motion dated 21st day of March 2025. The petitioner is permitted to withdraw the exhibited documents upon filing copy of the same.
Certified copy of the same.
Yes.
I have already obtained by replacing those originals of the. I will file.
Withdraw the originals upon filing the copies, certified
By
copies.
filing the supplement.
Yes.
Supplement. Great.
My lord, I'm
appear for the petitioner. This is my
appearing for the
application. This is my
plaintiffs.
application, my lord, seeking an inquiry into a act of perjury that has been committed by the plaintiffs before, my lord.
You
My lord, I am the
For the plaintiffs in the original testamentary suit, my lord, I'm just praying for a short passover. I'm
My lord,
led
here-
by Mr. Sengupta in the
Okay, let it be not today.
my lord, only one submission. My lord, at this stage, my lord, this is an application coming up for admission. My lord knows in a proceeding under section 340 that the respondent in the application has no locus standi at all. They have no right of audience. And I'm carrying.
Let them appear on the next day. Let
Well,
it be just let it be not today.
Grateful, your lordship.
Oblige.
23, my lord, I beg to appear for the defendant in the suit.
The
The applicant petitioner in IAGA 4. It is my application, my lord, praying for amendment of the written statement to, my lord, add certain paragraphs. Now, my lord,
It is your application.
my application,
And affidavits are complete.
affidavits are complete, my lord. Now, my lord, my submission first, my lord, is that these additions, my lord, the amendments that I pray for are absolutely necessary, my lord, for the adjudication and complete and fair adjudication of the issues before your lordships. The only defense, my lord, or the only opposition taken by the plaintiff is that the matter has been pending for a long time and this is a belated stage.
You have filed your reply also.
We have filed a reply as well.
Yes. What amendments did you seek?
My lord, the amendments are at, my lord, paragraph 12 at page 6.
That is page 40. Page
6 of the application.
Page 6 of the application. Yes.
Paragraph 12. The 1A, 1B, I have enumerated the paragraphs that I seek to add.
What is the nature of the suit?
Well, the nature is, the plaintiff has sought, assessment of mean profits. I was in possession of a certain office, which, I say was owned by another person. During the possession, it appears that the title of the property was changed. I kept asking, when I was approached by the plaintiff to pay rent to the plaintiff, I asked them that show me documents or show me the title that you have got, because as far as when I entered the property was owned by someone else. That took some time because they had not perfected the title. That's my stand. And once they perfected the title, they approached the court for seeking vacating of the property as well as mean profits. During the pendency of the suit, I vacated the premises and handed over the possession. Now, the suit is only, for assessment of mean profits. So, I have only sought to add certain paragraphs, showing the background as to, how I entered the property and what has been my status in the property.
Yes. What do you say?
The suit
No,
for
I-
eviction.
one second, I apologize. I am carrying judgments of the Honorable Supreme Court, which says, that in the amendment of a written statement before trial has begun, your lordships have to be liberal with that.
Please give the judgment.
Yes, your lordships, may I place the judgments, or
No. You just give it.
I'll indicate the relevant para numbers of it.
You state for the petitioner.
For the I'll indicate.
My lord, suit for eviction and determination of mean profit, my lord. My lord, I am a subsequent purchaser. My predecessor initiated the suit against Indian Oil Corporation for eviction, seeking eviction of them as tenant, my lord. My lord, during pendency of the suit, I stepped into the shoes. There is a chapter 13 application in furtherance whereof they have delivered the position. Now the only thing remains is the quantum of the mean profit,
For the degree of the mean profit.
for the degree of the mean profit, my lord. My lord, the suit is of 2013. They filed a written statement initially in the year 2015. Now, between pendency of the suit, there are several discussions so far as amicable settlement between the parties. Now the settlement has been failed, my lord. Upon failure of the settlement, only in the year 2024, they came up with this application seeking amendment of the written statement, my lord. So far as the legal proposition concerning amendment of the written statement or any pleadings of whatsoever nature, my lord, that is governing under the Order 6, Rule 17 of the CPC, my lord. So far as the plain and written statement, there is no difference. And I whatever my learned friend has just submitted, my lord, so far as the legal proposition led by Supreme Court are concerned, the court has time and again asked that the liberal view should be approached. But the only difference or exception, it has to be supported with a cogent reason. And
you see, while considering petition for amendment, court cannot go into the merits of the
matter, my lord. Absolutely.
whether it should be allowed or not at this stage at which it is considered.
My lord,
You see. So regarding merits,
I'm not harping on the merits, my lord. My lord, the only thing, paragraph 1L, what my understanding, what is the necessitated at this juncture to file a amendment application, page 9 of their application, paragraph 1L, my lord. If I am allowed to place, in view of the above, the plaintiff respondent is not entitled to claim any mean profit, even for the sake of argument. It is presumed, though not admitted, the plaintiff respondent is entitled to seek.
Page 9.
Page 9 of their application, paragraph 1L.
1L.
1I, my lord.
After H.
My mistake.
Yes.
My apology, my lord. Even for the sake of argument, it is presumed that though not admitted, that plaintiff respondent is entitled to seek mean profit, then also ADR of REN mean profit cannot be made over till July 26, 2013. That is the date of sale deed, as the predecessor in title of the plaintiff has not transferred such right in favor of the plaintiff respondent, my lord. Lord, this is their case. Now, my lord, my limited submission is that in furtherance of this paragraph, my lord, or and under the garb of this amendment, which they intend to carry out after a period of 10 years, my lord, they are trying to build upon a new case, whether my entitlement over the mean profit has to be considered or not. And my lord, one more thing, kindly take the ground on which they have stated that the delay has been attributed. Lord, my lord, paragraph 9, page 5 of their application, where they have tried to substantiate their part of delay in taking out this present application seeking amendment of the written statement. If I'm allowed to place, I say that the deponent of the said written statement, Mr. Such and Such, was the authorized signatory of the defendant petitioner for affirming the same. However, Such and Such is presently no longer with the Such and Such, the defendant petitioner. Only recently it has come to light that important and essential background facts have been omitted from the said written statement. Therefore, in the interest of justice and for the fair and final adjudication of the present case, the defendant petitioner prays for amending the said written statement. My lord, with deepest of respect, my lord, there cannot be a more casual approach seeking amendment of written statement after a belated period of 10 years. My lord, just
when did you enter into the picture?
My lord, I entered into the picture, my lord, in 2014, my lord.
2014.
2014 or 20.
And this is the suit of which year?
2013, my lord.
No, suit of which year? This one?
2013, my lord.
2013.
2013.
You came into the picture 2014.
2014.
And this is in 2024.
2015, they have filed the written statement, and
No,
this application 2024, my lord.
2024. The evidence has started.
No, my lord.
My lord, no. My lord,
Even issues have not been
if your lordship be pleased enough to kindly look into the order passed by other benches, my lord, concerning this matter, several times opportunity has been given to file their suggested issues. They refrain from doing so on the pretext of filing there is an amicable settlement. I do not deny there is an amicable settlement, but the attempt was all through from my end. For the past 2 years, I did that. Now, they also relied upon the amicable settlement.
You are in possession. Entire
I am in possession. That is not disputed, my lord.
Only this monetary,
only the quantum of the my lord. Now, the case which they are built upon right now through seeking this amendment of the written statement, my lord, this was not there when. So it's a new case, and with that, the same is beyond the ambit of the Order 6, Rule 17 principles, my lord.
No, that is not correct. If I may,
My lord, may I rely on two judgments? This recent Supreme Court of 2023, my lord. 2022, my lord. My lord, this is Life Insurance Corporation versus Sanjeev Builders, my lord. My lord, page 14, internal page 14, paragraph 18, my lord. This has been considered, my lord, all the other judgments which has been passed on the same line. Lord, paragraph 18. 1 second. 16 SCC 1. It is well settled that the court must be extremely liberal in granting the prayer for amendment. If the court is of the view if such amendment is not allowed, a party who has prayed for such an amendment shall suffer irreparable loss and injury. It is equally well settled that there is no absolute reason in every case where a relief is barred because of limitation, amendment should not be allowed. It is always open to the court to allow an amendment if it is view that allowing an amendment shall really serve the ultimate cause of justice and avoid further litigations. Lord, now, my lord, with deepest of respect, I ask this question to myself: what ground they have come up with for elaborating by way of this amendment the background of the suit, what happened in the past years before when my predecessor was there? My lord, the only pretext they have not deposited the rent on the question on a doubt, on a reasonable doubt that who is the owner. So far as the law is concerned, a tenant cannot even question the owners of the owner.
Question is, was there any refusal on your part to receive the rent?
Well,
any notice was issued from your side?
No, my lord.
Although this to be adjudicated at the time.
At the time of trial, my lord.
No, but question is, if there was a bona fide doubt as to the ownership, they can deposit before the rent controller, or in court also.
Or in court also, they could have seek leave before the court, my lord.
How many months rent did they fail to deposit?
My lord, their area is from 2013, my lord.
The suit is up to 2013. And regarding payment of rent to you?
1993, it was due. My lord, their affidavit of reply, my
You see, the ground for eviction was default in payment of rent. What is the ground for eviction? Or the expiry of the lease?
My lord, expiry of the lease, my lord.
Expiry of the lease.
If your lordship be pleased to take page 7 of their affidavit in reply, they have relied upon the settlement which will otherwise depict.
You see, ultimately, whatever the parties have to establish it at the trial of the suit. Okay, that is the main thing. Anyway, what is the relevant paragraph?
My lord, paragraph 18, my lord, the discretion to be exercised by the court has to be upon keeping in mind that the ultimate purpose for which this amendment has been brought.
Yes.
And my lord, subsequently, paragraph 23, these are all the precedents which has been cited by the Supreme Court, my lord, in considering this judgment. The power, paragraph 23, power to allow an amendment is undoubtedly wide and at may any stage be properly exercised in the interest of justice. The law of limitation notwithstanding. I'm not taking the point of limitation whether they should have come earlier, whether they should have, but what is the
section is clear. Order 6, Rule 17. That is
before
clear.
commencement of the trial. There is no doubt about on that proposition, my lord. The only thing is what they intend to brought in through this amendment.
According to you, they are trying to bring out a new case.
A new case altogether, which will otherwise endure to their benefits, that I am not entitled for mean profit for such and such period, which was not available when their written statement was there prior to this.
They filed the written statement after you purchased the property.
After I purchased.
Actually, the original plaint which was served upon him, he has already filed a written statement on that. On the original plaint.
No, my lord.
So after you entered into the picture, there was any amendment about the cause of action?
Yes. There is an amendment in the plaint only.
Plaint
only, and subsequent thereto they had filed their written statement.
And you have obtained the decree of eviction.
I have obtained the decree of eviction.
And it is complied also.
It has complied. I am in possession. There is no doubt about it. The only thing remains is the quantum of the mean profit which I will be entitled to. And the area rent also.
Anyway, this is the only judgment you want to cite.
Well, another of 2015. This is also of Supreme Court 2015 10 SCC 203.
Yes.
Well, this is a case of amendment of written statement, my lord. The factual background, it will elaborate from paragraph 10. After 15 years, the written statement on such and such date, the defendant number such and such filed an application seeking amendment, my lord.
Yes.
And the observation, what will be the criteria and under what circumstances this application of a nature of under Order 6 Rule 17 can be allowed has been given under paragraph 20, my lord. On amendments generally in the decision report in such and such, the principles on amendment have been summarized at para such and such. On critically analyzing both the English and Indian cases, some basic principles emerge which ought to be taken into consideration while allowing or rejecting the application for amendment. I am on paragraph 20. Whether the amendment sought is imperative for proper and effective adjudication of the case, whether the application for amendment is bona fide or mala fide, the amendment should not cause prejudice to the other side which cannot be compensated adequately in terms of money. Now, my lord, the case which they try to build upon by way of this amendment will otherwise affect me financially, which I would have been otherwise entitled for, my lord. Refusing amendment for the fact lead to injustice or lead to multiple litigation, whether the proposed amendment constitutionally or fundamentally changes the nature and character of the case, And 6, as a general rule, the court should decline amendments if a fresh suit on the amended claims. This is not relevant at this juncture. No, that is it, my lord.
May I just quickly respond, my lord, in 2 minutes? My first point taken by my learned friend is that the case was not made out in the written statement earlier. My lord, kindly has, my lord, paragraph 10 of my written statement. Paragraph 10 at page 13. 1-3.
Yes.
It is submitted that the right to recover arrear rents and/or main profit has not been transferred by the original plaintiff to the present subsidiary plaintiff. So, my lord, this plea has been taken in any event, my lord. If I may, my lord, this judgments I have placed before your lordships. If your lordships kindly takes up, my lord, only 2007, volume 6, SCC 167, paragraph 6 specifically.
Whatever you have cited.
I have cited, my lord. Paragraph 6 clearly says, if I may read. This is, my lord, 2007, volume 6, SCC.
Yes.
But if your lordships has paragraph 6 at the page 170 of the report.
No. 2007, 5 SCC, you want to say?
2007, volume 6, SCC, page 167.
Yes.
Paragraph 6 of the judgment, my lord, at the report page 170.
Yes.
That apart, paragraph 6 of lordship, that apart, it is permissible in law to amend a written statement of the defendant by which only an additional ground of defense has been taken. So, my lord, the argument that by adding a point of defense or a point of defense, that is, my lord, prejudicing the plaintiff. That is not so, my lord. Honorable Supreme Court has itself held that it is permissible even to add a new defense to the written statement, even though I have shown to your lordship that paragraph 10, I have pleaded that the right to claim mean profits has not been transferred to the present plaintiff. So, my lord, there can be no prejudice caused to the plaintiff by allowing this amendment. And on the point of, my lord, delay, my lord, I made the application in November 2024. Now we are, my lord, in May 2025. 6 months have already gone in trying to oppose this application. So, my lord, my humble submission is that had this been allowed, then, my lord, no delay would have been caused and we would have been proceeded with the trial already. My lord, trial has not commenced as yet.
Yes, record an order. Learned advocate for the petitioner and learned advocate for the opposite party, learned advocate for the petitioner defendant and learned advocate for the opposite party plaintiff are present. The application GA 4 of 2024 is taken up for consideration. Heard learned advocates on the petition. The hearing is concluded. Fix 20th of May 25 2025 for orders. 25.
Grateful.
Court does not have determination with
Yes.
regard to admiralty suit.
Yes, my lord. Perhaps that is.
So, item 44.
Yes, my lord.
Lordship.
This court does not have determination, so the matter has to be released.
Very well.
Yes. Learned advocate for the petitioner, plaintiff is present.
Time for the defendant.
The
Learned
plaintiff
advocate
led
for the
by
plaintiff.
Mr. Pranit Bag.
Learned advocate for the defendant are present. As this court does not have determination to hear admiralty suit, the matter stands released from this court. The matter may be placed before the court having determination.
Very well, Lordship.
Grateful, my lord.
My lord,
Yes,
this is my
Mr.
application.
Chief.
I'm for the response.
You are for?
This is basically an application for passing a preliminary decree in a suit. My lord, just to tell my lord in short, suit property is on Wellesley Street, about 46 katas and odd, very valuable property. The then owners made the property into 3 lots and decided to sell lot by lot. I purchased 50% share in one lot, 75% share in another lot, 50% share in another lot. After that, the parties fell out and the conveyances were executed only as I've told you. The rest, so I filed 5 suits were filed in total. 2 suits for specific performance, 1 suit for partition, and my learned friends filed suit for cancellation of the deeds in my favor.
19. This is suit of 19.
My lord, nothing remains here now. What happens was that these 5 suits were disposed of by a common decree. Because what happened was that my learned friend filed an application for preemption. That application for preemption was allowed, and all the other suits for partition, cancellation of deeds, etc., were dismissed. His preemption application was allowed, and he was directed I was directed to transfer the property to him at a price to be fixed by the registrar. Now, an appeal was filed by me against such order because it said that if I do not sell, what will happen? But the decree did not say, by inadvertence probably, if he does not pay, then what happens? So it went up before the appeal court. The appeal court modified the decree only to that limited extent.
Also extended the time.
Yes, and said that yes, fix a time, and within that time they are going to pay. Now, my lord, I'll just place the appeal court order because my lord, this application.
No, I am hearing GA 13 of 2020.
My lord is hearing GA 30.
It's your application.
Which is my application.
And your status in the suit?
My status in the suit is in this suit as plaintiff.
That is of 1987.
Of 87.
But my land friend's contention is that because I failed to pay the money in terms of the, so that decree is automatically recalled and he is now entitled to partition.
That is what the appeal court says.
Yes. So that is correct. I tried to make payment,
Anyway,
could not arrange money.
GA is your application. So GA has to be heard out.
Yes. My lord will kindly take the.
And affidavits are complete.
Everything is complete. My lord, there is no real scope for any affidavit, but my lord, they were given a scope, they filed it.
Yes.
Because the appeal court has limited the scope.
The pro forma defendant's death be recorded.
Yes. He was my vendor. So I had made him a party. I own and he owns. There is no other owner here. My lord will come straight to Annexure I at page 162, which is the judgment of the appeal court. Well, I'll just place the first 2 paragraphs here and then I'll take you to the
162. I think it will be in the other.
It will be in volume 2.
Yes. Volume 2 ta din.
Hey, how was din?
Second volume ta din.
162.
My lord.
Yes.
Well, let me just place the first paragraph. 5 suits were tried together by the learned single judge and decreed on 12th September 2014. Woodland Manufacturers Limited appeals to the court from that decree. The property involved in premises number 78 Rafi Ahmed Kidwai Road, Calcutta. For the purposes of this suit and this appeal, the property is to be taken as having 3 lots, 1, 2, and 3. It was undivided. Woodland is the owner of 50% share in lot 1, 75% share in lot 2, and 50% share in lot 3. It was already owned by them at a material point of time. Then, my lord, he goes into all these suits. My lord will not have to, it will not be required for my lord to consider these 50 pages. My lord will straight come to page 175.
175.
My lord.
Yes.
My lord, the second paragraph. In those circumstances, the impugned judgment in decree has to be treated as a preliminary decree. Since there was no default on the part of either party, there is occasion, in my opinion, for passing a further preliminary decree balancing the equities. My lord, just to give you a bit of background, the price was to be fixed by the registrar of assurances. What happened was no time limit was given to the registrar to complete his job, and he sat over the matter for 4 years. So he said, registrar is not fixed, therefore I have not paid. Since there was no fault on the part of either party, there is occasion, in my opinion, for passing a further preliminary decree balancing the equities. On the date of making the application under Section 4 of the said Act by Shankar, that is my learned friend's client, 12th August 2009, the valuation of the property was 9 crore 44 lakhs and odd. According to the above reasoning, this amount was payable very contemporaneously to the filing to the date of the said application. Therefore, if the valuation and payment were made within time, Woodland would have received this amount within a reasonable period after 12th August 2009. Let this reasonable period be 3 months. So Woodland should have been bought out by 31st December 2009. I would hold that Woodland was entitled to enjoy the benefits of the money from the date of receipt of the consideration till date. This is reasonably assessed at 10% per annum, simple interest. In those circumstances, it would be just and proper to subserve the interests of justice if Shankar pays to Woodland the consideration of 9 crore 44 lakhs 69,000 on the valuation made by the registrar, together with 10% simple interest thereon, for the period commencing from 1st January 2010 till the date of this preliminary decree, and thereafter further 10% simple interest per annum from this date till payment, which has to be tendered by 20th March 2020. My lord will mark this date. Woodland will convey the right title interest in the said property to Shankar on 20th March 2020. On default by Woodland, the Registrar High Court shall execute the conveyance by 30th April 2020 in my film. On the default of Shankar, this suit be placed before the learned judge for passing a preliminary decree for partition. I pass a preliminary decree accordingly. Furthermore, the sale deed shall be registered on the same day as the payment of consideration. Woodland shall not raise any dispute with regard to the draft conveyance submitted by Shankar. Shankar will continue to remain in possession until further orders. If there is default on the part of Shankar in making payment of the consideration by 20th March 2020, Woodland shall apply before the court below to pass another preliminary decree for partition. This is my present application. No further inquiry is to be made by the court below, except with regard to the payment of consideration within the stipulated time. If it finds that the consideration has not been paid, a preliminary decree for partition, assuming the shares of the parties to be admitted, shall be passed by it. If this happens, the court will proceed further to pass a final decree for partition. It is made clear that under no circumstances the time to pay the consideration is to be extended, and the above directions are peremptory. The impugned judgment and decree as such is modified to the extent above. So, my lord, they failed to pay either the 9 crore 44 or any interest amount within 20th March 2020, which was the date fixed. They moved to the Supreme Court against this. The SLP was dismissed. They filed a review thereafter before the Supreme Court. My lord will take the orders. My lord, at page 178, my lord will see there's a SLP order.
178, yes.
Then, my lord, after they were still not satisfied, they filed a review. The review was also dismissed, which my lord will find at page 180. So, this order and the date of 20th March 2020 has become final. They have failed. Then I take out this application in terms of the direction passed by the appeal court. If they don't pay, I will come to you. You will pass the preliminary decree determining these shares. They file an affidavit in opposition. They take 2 points. Firstly, they say that there was COVID. So I should be entitled.
No, you see, this order was passed by the Honorable Apex Court, I think, during the COVID period itself.
Yes.
This
And in any case,
dismissal.
it was peremptory and the COVID and the court didn't interfere. But even if it was otherwise, they say COVID period of 9 months or 1 year.
No, COVID period from March 2020 till February 2022. This
Any
2
case,
years
after
was
that,
COVID period.
any case, even if we extend that, till today they have not paid.
No, but when your application was taken out.
This application.
Yes.
This application was taken out.
2020.
This application was taken out in 2020.
Anyway, this application is pending, so there is no question of any payment.
No, how? The direction passed by the appeal court to make payment by 20th March was not stayed. They went up and they went up before the Supreme Court.
This application of yours is pending.
My application is pending.
So there is no the question. Once this application is pending, prior to that, they ought to have extended.
Exactly. And even the Supreme Court didn't extend it. Supreme Court's order was September 1st, 2020. I don't think he's really serious about his objection. I mean, he can't be. My lord, and one more point he takes.
Here is 2 alternatives. Either you have to settle or the order of the Supreme Appeal Court is binding.
Appeal Court is binding.
Otherwise, if you can settle, that's a different issue.
There's nobody's throwing him out. He is entitled. He is entitled to his share. My suit for specific performance was dismissed. His suit for cancellation of bindings was dismissed. So we are back to that position. As determined by the first paragraph of the appeal court order, I have 50% in 2 lots and 75% in 1 lot.
No, that preliminary decree has to be passed.
That preliminary decree has to be passed. That formality has to be completed and a commission of partition has to be appointed. But that only inquiry to be made is whether they have paid.
Yes.
The only inquiry that this court can make in terms of the order passed by the appeal court.
Your contention is they have not paid.
My contention is not paid. They filed an affidavit. They do not say they have paid.
So what is the stand in their affidavit?
Yes, their stand is 2. Firstly, they said that I should be entitled to an exemption for COVID. Even though Supreme Court didn't give it, they are saying the law gives it to them. Therefore, they're entitled to that extra period, 1 year or whatever, for COVID. And another point they take is that I had filed another application, another suit for partition. What happened was that since they had not paid in terms of the original decree passed by the trial court, I had filed it and the time had gone. I had filed a suit for partition saying your right of preemption was granted to you. You have failed to buy within the time. Therefore, that preemption application goes. We are back to the square one. I'm entitled to partition. But when the appeal court extended the time, that suit became infructuous. I've said so in any case, that suit is, therefore, I have not proceeded with that suit. That suit has been dismissed. And this was only to
preemption. What is his status? He's an outsider.
No, he's not. He's my co-owner.
Oh, so no. Oh, co-owner has been proposed.
Yeah, he was the co-owner.
No, it was originally sold to third party.
No, he
preemption means what? Third party, and then
he entered into an agreement to sell along with his co-sharers.
Yes.
Co-sharers sold, he did not sell. That's why the suit.
In the suit, I took the point that because there were co-sharers, all families from the same family, first class heirs. So under Hindu Succession Act, I have a right of preemption. Instead of selling it to him, my co-sharers ought to have sold the property to me. That was my stand, which was upheld. I could not pay. It's true.
Anyway, that order cannot be.
Yeah, he admits that he could not pay.
Thereafter, this partition.
Thereafter, this partition. Therefore, now what is left is my lord is to pass a preliminary decree. The shares have already been determined, which is there in the first paragraph of the appeal court order. A commissioner of partition is to be appointed. There's already a special officer appointed who in other proceedings, who is taken
in this matter.
Who's gone, who's made inventory from time to time. I would say he He is aware of all the facts.
Same person
If-
can be same person can
Yes,
be
still let his advocate of this
let's work from him because he has already done this task once.
Maybe see Mr. Ken Jana, an advocate of this court, was appointed.
A special officer. And
There he was appointed as special officer for the purpose
special
of...
officer can appoint the partition commissioner, surveyor
No,
commissioner.
I'm saying the special officer has been appointed. He is made inventory. Let the special officer, let the same advocate who was appointed as special officer be now appointed as the commissioner of partition.
Anyway, that can be considered whether he should be appointed or some other person should be appointed.
I don't think anybody has an issue with that because that's going to be most convenient for everybody.
He is appointed, it will be easier for the parties also because the parties have already dealt with him once.
And he knows because he's been going, he's filed several reports before the court. He's aware of the property.
Development and everything.
And shares are not in dispute.
So he was appointed as special officer. Now he is to be.
Now we are praying that he be the same person be appointed as a commissioner of partition.
I think this is not done by advocate commissioner. There is a surveyor commissioner.
No, it is not required.
High Court.
Anyway,
what happens here in the High Court, what an advocate is appointed, he is given the liberty
to appoint a,
to appoint a valuer and a surveyor.
Surveyor commissioner.
Yes. No. He is a commissioner. He will appoint a valuer and a surveyor.
Surveyor. On the basis of that report, he will file his report.
Yes, or if the parties can come to a settlement and approach him together.
No, the commissioner with the assistance of the surveyor fellow will file that.
Yes.
That liberty lordship will give to the commissioner.
What are the affidavits?
But, should be on record. I've got a copy.
Already.
Affidavit.
The opposition.
The reply I can find here. The opposition should also be there.
Affidavit in opposition is there.
Yes, if the reply is there, opposition should also be there. My lord can proceed with the copy. Copy it. My lord will take a copy.
Anyway, I am concluding the hearing.
What should we pass the order?
My lord will pass the
I'll
order.
pass it within a few days. Learned advocate for the petitioner. Your petitioner, opposite party, defendant.
I am for the defendant number 2.
He is for defendant number 2. I am for the plaintiff.
Learned advocate for the petitioner, plaintiff, and learned advocate for the opposite party, defendant number 2 are present.
He is actually the only defendant.
Original defendant number 2. Now the only
number 1 is died.
The prayer 1, the prayer aim that is the.
My lord can also consider this order where the same special officer was asked to submit his report and his report was kept on record. My lord.
The same special officer.
Yes.
First name is there.
GA 13 of 2020 is taken up for consideration. Heard learned advocates for the parties. The hearing is concluded. The matter be fixed for orders on 15/6/2015. 15/5/2015.
15/5. My lord is marking it, or my lord not marking it as CAV.
Marking it for orders.
For orders. Very well, very well.
On that day, orders will be passed. Okay. Hearing is concluded.
15/5. Well.
Yes,
Yes, not today.
Item number 26 in the goods of Fukit Chand Dahata.
Not today.
27 in the goods of Ashrafi N.
Not today.
Old suits. Item number 28, Pankaj Killa.
Yes, item 28.
Yes, Your Lordship, I appear on behalf of the defendant, Your Lordship. This matter was taken up on the last occasion on 29th April, wherein Your Lordship has directed us to write to the plaintiff's advocate, intimating them the next date. I have sent a letter to them on 1st May, Your Lordship, The same was received by his clerk, but Your Lordship, they have not taken any step in this matter. Your Lordship kindly dismisses the suit for non-prosecution. Your Lordship. The plaintiff has not taken any step. It's been 25 years, Your Lordship.
Upal Singh. Upal Singh.
আমি লিখে দিই লিখে দিচ্ছি।
Yes, record an order. Learned advocate for the defendant is present. None appears for the plaintiff. In spite of none appears for the plaintiff in spite of intimation given by learned advocate for the defendant. It further appears that on 29th April 2025, the matter appeared, but none appeared for the plaintiff. In the facts and circumstances, considering the year from which the suit is pending, this court is of the view that an administrative notice is required to be served upon the plaintiff and his learned advocate. Hence, an administrative notice be served upon the plaintiff and the learned advocate, and by 11/6/2025, and a report be submitted to this court on 16/6/2025. Yes, it will appear on 16/6.
Grateful, Your Lordship.
29.
Letter to be kept with the record.
Yes, yes, letter will be kept.
29. Barak Vanijya Private Limited.
Yes, not today.
30. Fast Flow Delcom. 31.
Not today.
32. Fast Flow Delcom. 33. Mridula Desai.
Same.
34. Jhajar Investment and Trading. 35. Jhajar Investment. 36. Prime Tradecom Private Limited.
36.
Yes, my lords. My lords, I'm appearing for the plaintiff in this matter. My lords, since our office at Temple Chambers had caught fire, so the building, we are unable to trace the records. So I'm praying for an adjournment for a longer date in this matter, my lords.
Yes, item 36. On the prayer of learned advocate for the plaintiff.
Plaintiff, my lords.
Plaintiff. The matter stands adjourned till. I'm keeping it after vacation.
Yes, my lords.
Matter stands adjourned till 18/6/2025.
Much obliged, my
Plaintiff, the learned advocate, shall take necessary instructions and get ready in this matter, and serve a written notice upon learned advocate for the defendant, intimating the date fixed.
Much obliged, my lords.
37. Dr. Shoshi Tharoor.
Yes, not today.
38. Quicker Chemical India Limited.
Same.
39. Services Limited.
I appear for the plaintiff in this matter. On the last occasion, writ of summons had been issued to the defendant. Still none appears, and then we are praying to file an application for undefended suit.
Have you taken out any application?
No, we'll file an application for undefended suit.
39.
Yes, 39.
Yes, record an order. Learned advocate for the plaintiff is present and prays for time to file necessary application to treat this suit as undefended suit, as none appeared for the defendant in spite of service of summons. The case stands adjourned till. I'm keeping it on the reopening 10/6/2025.
Publish.
under the same heading.
Antariksh Vyapar Limited. 41 Messrs. Neocarbons. 42 Sri Lakshmi Iron and Steel.
Lordship, I am for the plaintiff, Lordship. I have received instruction from my client not to proceed with this matter. I have a written communication.
Yes, learned advocate for the plaintiff is present. Learned advocate for the plaintiff files a written communication. Learned advocate for the plaintiff files the notice issued upon him by the plaintiff, intimating that the plaintiff does not want to proceed with the instant suit. In the facts and circumstances, this suit stands dismissed for non-prosecution. Let the letter dated 6th May 2025, issued by the plaintiff to his learned advocate, Mr. Abhijit De, be kept with the record.
Great.
Item number 43, Bonanza Infrastructure. For hearing, item number 45, Dr. Ajoy Kumar Mukherjee and another.
We are for the defendant. We are for the plaintiff.
My lord, I am appearing on behalf of the defendant. My lord,
Yes.
I have instruction. We are not going with their
They are not
proposal.
agreeable to parties. You are trying to settle it. Partition suit. Defense is struck off. Preliminary decree passed. They have given undertaking. They will not touch, disturb. All that.
So a final degree has to be passed.
Has to be passed.
Settlement failed.
Said, instead of going for partition commissioner and everything, incurring further cost, we said, I'll purchase whatever is your share, I'll pay and purchase the.
So are they agreeable?
Not
No, my lord.
So today is fixed for what? Final for passing the final degree.
Final, not instead of decree, also will appoint a partition commissioner. Commissioner will give a report, then that report will be acted upon through a decree. That's the.
You are representing whom?
The defendant.
Oh, this is the sole.
Yes.
How many plaintiffs are there? Two.
Now two, because the son of the plaintiff number one was also added as a party under my application.
So,
because during the pendency of the suit, the one defendant number one had transferred his shares to the son.
So one that is two plaintiffs and
50-50.
And only
one defendant.
50%
plaintiffs, 50% defendants. That is admitted. Instead of going for partition commissioner, we were suggesting if we can.
My lord, we have specific instructions. My lord, and apologies, Your Lordship. We have specific instructions, my lord. Let the partition commissioner be appointed.
Yes.
Let both of us bear the cost, not the plaintiff only.
No,
both
Give me the records. Give me the copy of that preliminary degree. Order.
Just give me 1 minute. Let's find it. The application order data.
No, where is the preliminary order passing the preliminary decree?
Justice driver order. 31st July 2023. May I hand over? I can. And it was annexed to my application. I'm just handing over the copy.
Yes, learned advocate for the plaintiffs and learned advocate for the defendant are present. It is submitted by the learned advocates that although the preliminary decree is passed on July 31, 2023, and talks for settlements were going on between the parties, but the settlement has failed. Thus, a partition commissioner be appointed to cause necessary partition and to submit a report to enable the court to pass the final decree. Upon hearing the learned advocates and considering the facts, this court is of the view that the partition commissioner should be appointed. Thus, blank is appointed as a special officer to cause necessary partition of the suit property in accordance with law after holding necessary discussion between the parties and making endeavor to make an amicable settlement. Stop. In the event the learned special officer is unable to make the amicable settlement with regard to partition, he shall, upon discussion with the parties, appoint a surveyor and a valuer to make the survey and valuation, and on the basis of the survey and valuation, he shall prepare his report with regard to partition of the suit property by metes and bounds and submit the report before this court by 19/6, yes, 2025, 19th of June.
50-50 তো কোনো অন্য কিছু মিটস এন্ড বাউন্ডস করতে হবে
19th of June.
Lordship will appoint some lawyer of our court,
Yes,
some
yes, yes.
advocate of our court to take.
Yes, yes, yes. That I've kept it blank. Okay, I shall appoint it. The initial remuneration of the learned special officer shall be.
Lordship can consider Mr. Dev.
Okay. Anyway, on some other occasions I can appoint. On some other occasion, definitely I shall consider and appoint. Some other matters. Of the learned special officer shall be 1200 GMs to be shared by the parties. To be shared by the parties.
Amended printer.
Yes, I am appointing Mr. De. ওইখানে special Mr. Prosenjit De be appointed as the special officer. ঠিক আছে? So 1200 GMs to be, sorry, yes, 1200
for his remuneration, but the surveyor and value that will
Yes, yes,
that will be
that
will kindly leave it
initial
to him.
remuneration 1200 GMs to be shared equally by the parties. The cost of the valuer and surveyor shall also be borne equally by the parties according to their shares, and the payment shall be made by the parties. The expenses of survey, incidental expenses of survey shall be borne by the parties as per their shares. To fix 19/6/2025 for report.
Kindly will not keep it towards the end of that month because it will take time. And in the meantime, there is a vacation, no one will be available. Either end of that month or early July.
Okay, 26.
26.
26/6.
Yes, yes, ma'am.
2025.
At least some
Bow down,
progress should be done.
Grateful, Miller.
Deeply
But, may I take back that copy of application? I'll hand over the order sheet separately. I have a copy, Miller.
Yes, yes.
Application of copy.
ওই 31st অর্ডারটা আমি হাতে দিয়ে দিয়েছি রেকর্ড করে তোমারই কপি
Grateful, my lord.
গ্রেটফুল
For framing of issues, item number 46, Amit Tiwari.
Lordship, I am appearing for the plaintiff. Lordship, this is my suggested
Item
issue.
43.
46, 46.
46, yes.
Lordship, this is my suggested issues.
My lord, I am appearing for the defendant. On the last occasion, we had handed over a copy of our suggested issues and had also circulated it. And today, just prior to the matter getting called on, we were handed over with a copy of the suggested issues by the plaintiff, Your Lordship. I would require some time to go through it. And may I just come back on this on the next day? Your
Yes.
Lordship would kindly allow me.
Learned advocates for the, you are for all the plaintiffs.
Lordship.
Learned advocate for the plaintiffs and learned advocate for the defendant are present. Suggested issues filed on behalf of the plaintiffs be kept with the record. Copy be served.
Lordship, we have already served.
They have served here and now in court.
Let this matter appear on 15/5/2025 for framing of issues.
Grateful, Your Lordship. I shall come back.
Witness action item number 48, Mohesh Kumar Poddar.
Item 48, you are for?
For the defendant, my witness is present.
Plaintiff's advocate?
Plaintiff তো ছিল বাইরে এই তো এসেছে আমি দিকে
I appear on behalf of the plaintiff in this matter.
Your witness is present.
Witness is present.
Just
Whatever.
put one or two questions and
My lord, five, 6 questions to start off. Yes.
put
তো ওদিকে
some
চলে যাই,
questions
চলে
at that.
যাই। Yes. So already 4 o'clock is. ঠিক আছে চল।
So, yes, this is the PW1.
DW.
Defendant's
Oh, DW.
DW1. It's a money suit by the plaintiff. Some questions can be put. হ্যাঁ প্রথমবার ওথ হবে হাউ আর ইউ ঠিক আছে হ্যাঁ সেটা পারবে না ওটা আমি লিখতে গিয়ে আমারও তো সব একটু ঘুরিয়ে না হ্যাঁ ওই দেখছো 5% হয়ে অটোমেটিক চার্জ অনুজ ভাই এসে গেছে Develop 10 questions for today. For today. Follow syllabus, not that. Syllabus gang. ঝামেলা করছিস আজকে দিনটা হোক না হ্যাঁ Mr. Parekh, kindly tell the Honorable Court that how are you connected with the instant suit? Tell it to him. একটু জোরে বলো, the court can hear.
You are partner of which firm? Which firm? Yes.
Company. Can you name who are the other partners of this firm? NK, yeah. Are you aware as to when this partnership firm which you referred to in your last answer, namely East India Trading Company, was formed? আস্তে আস্তে বলো ভাই। When did your father die? 2000. During the lifetime of your father, who were the partners of this firm? Do you know since when your father was a partner of this partnership firm? What was the business, or what is the present business of this partnership firm? Who used to look after the day-to-day affairs of the firm? Are you aware? By the words at that point of time, which period do you mean? What was your role or the role of other partners when your father was alive in the partnership firm? Do you know any person by the name Mohesh Kumar Poddar? In which capacity you know him? By friend, what do you mean? Which market? Poddar Court. Court Ezra Street. এখনই ঘাবড়ে যাচ্ছে এখনই ঘাবড়ে যাচ্ছে তুমি পজ করলে কি হবে Are you aware what this Mr. Poddar used to do for his livelihood? Do you know as to whether your father and Mr. Poddar had any financial transaction ever? What was this nature of transaction? আস্তে আস্তে বলুন না কি সিজন করছেন কেউ বুঝবে না। চলো লাস্ট প্রশ্ন, অনেক হয়েছে।
Yes, what is the nature of work?
সেটা they were in
Please be louder.
হ্যাঁ
Can't hear you.
I can't hear it clearly, একটু জোরে বলুন। এখানে মাইক লাগাও না। হ্যাঁ এই ওখানে একটা মাইক লাগিয়ে দাও। হ্যাঁ
Yes, record it.
হ্যাঁ পরে পিডব্লিউডি কে বলে করিয়ে দেবে। Are you aware? হ্যাঁ হ্যাঁ আস্তে আস্তে বলুন, নাহলে তো সব ভুলে যাবে এবার। Are you aware as to whether these financial help that your father used to take from Mr. Poddar were done through cash transactions or bank transfer? And what was the method of keeping accounts or books that the parties used to maintain?
Anyway.
So your evidence is that your father used to avail financial accommodation from Mr. Poddar when required. Are you aware as to whether or how these repayments were ever made to Mr. Poddar? পার্টি আছে কি কি নাম আছে? উত্তম পার্টি আছে। আজকে অবধি তা। But may I conclude today for the time being?
Okay.
I'll continue.
Yes.
I'll take 15 finish off on the next day.
Finish it up on the next day?
Yes, yes, 100%.
Apart from him, other witnesses?
No.
To be, learned advocates for the parties are present. DW1, what is his name?
Uttam, na? Uttam Parekh.
DW1 Uttam Parekh is present in court. DW1 is examined in chief in part and discharged. Further examination is deferred on the prayer of learned advocate for the defendant. Let this matter appear.
Malad is recording that this discharged. I don't know.
No.
Is it discharged? Discharged
No,
may not
today.
Oh, for to discharge for today.
Release for today.
Always is discharge
Okay.
for today.
Discharge for today.
Yes. Fix. Further examination of DW1.
Kindly fix a short date. Well, very short matter.
Any day
any day.
after the vacation.
Why?
Hey,
It's fine.
it
Well,
could
we
be.
can. It's a short case of money lent in advance.
It's a 99 suit after all.
Yes.
Okay. I'm a defendant. I should not.
And I'll cross-examine him on the same day.
I'm a defendant. I should not. 21st or whatever.
21st.
21st, 20th, whatever.
Okay. 21st.
21st.
5/2025 at 3 p.m.
3 p.m.
Very well.
3 p.m. The witness convenient for 3 p.m. Change হচ্ছে।
কমপ্লিট হয়ে গেছে তো লিস্ট?
21 এই 21st মে।
ঠিক আছে।
Obligement.